Yeah, can you please try again now, Professor Mark, sir?
Okay, yep, now I can.
Yes, sir. Okay, there we go. Dr. Chandrani Babri, madam, can we start? Without much delay.
Yeah, we'll start.
Yes, yes.
Okay, so we'll start on.
Yeah.
Okay, so good morning to our today's speaker of the webinar, and good evening to chief guest and all the participants. I welcome all of you for today's one-day online international webinar on the topic from 1619 to Black Lives Matter, 400 years of the racial discrimination in the United States. Thank you everyone for joining. Now I call upon Dr. Dubdai sir, Head of Department, to express his few words.
Welcome to you all, and good morning to Professor Mark Brown and all the participants who are having good morning right now, and good evening to all those who are having good evening right now. Okay, welcome to this international webinar, and we'll be talking about the racial discrimination which is going on at basically at US. And that's the main topic that we have today at today's discussion. But let me speak some few words about the racial discrimination. It's going on all over the world, not only in US. I have an experience in my department itself. There are some African students who join every year in the department. Every time when they join, they are being discriminated by Indian people. They just isolate them. They don't include them into their own discussion groups. They don't speak to them. They just treat them like aliens, and then they come and complain to me. They say that Indian peoples they don't talk to us. I just give them an explanation by saying that maybe they don't understand your language, foreign language. But that is not the issue, because uh, they say, and some of the students I have heard by saying that Africans are they look dirty and all those things. I try to explain to them it's not the color and it's not the look that is important. It's the human being, because we teach human rights in our course, and then I try to explain to them that there's nothing to do with the color. I would like to share another experience of one of my friends. Uh, we in India, we have a hierarchy of caste system and class system. We have the Brahmins at top and Shudras at the end. The Brahmins are considered to be the topmost caste in India. One Brahmin from one of the Brahmin from North India and one more Brahmin from Konkan area. They went to England and they were speaking to one English woman, an English lady. After speaking to for some time, she just said, "Let me stop now, and I want to go." They immediately said, "We have just started talking, and you are saying that you want to go." Then she suddenly said, "If I continue talking to you, those people will tell me. I mean, will say, are you talking to black people?" And then they will start shouting at me. So that's the position of as far as racial discrimination is concerned around the world. The people who are treated at top in India may be discriminated elsewhere, because it's though these Brahmins they are very fair and beautiful looking people. They are considered to be the top caste in India, but see, they have been discriminated because they are Asians. So with these few words, I I would like to express my sincere thanks to Professor Mark David Brown for accepting our invitation and acting as a resource person, chief resource person for today's webinar. I would like to express my sincere thanks to Professor Dr. Marian Pinero sir for joining us as the chief guest. So welcome to him. And then I would like to express my sincere thanks to Advocate Malushti sir, Rashekar Malushti sir, who has been associated with this department for so long. I think he missed the GAN program. Otherwise, he would have enjoyed a lot with all of us and technically also in other things. So, with these few words, I'd like to hand over the further program to Dr. Chandrani Babu. Over to you, ma'am.
Thank you, sir. Now, I would like to introduce today's chief guest of the webinar, Professor Dr. Mario Pinero, sir. He completed his LLB and LLM from Karnataka University, MA in Political Science from Karnataka University, B.Ed in English and Political Science from Tamil Nadu, BSc in Chemistry from Karnataka University. Former positions he held are Pro President equivalent to Vice Chancellor, Raffles University, Rajasthan from 2012 to 2013 and Honorable Dean from 2014 to 2015. Principal Director, Vivekanand Institute of Professional Studies, Pitampura, Delhi from 2014 to 2015. Director, Lloyd Law College, Greater Noida from 2013 to 2014. Dean, Faculty of Law, Goa University from 2003 to 2012. Principal of VM Sargavkar Law College of Goa from 1996 to 2012. He has achieved various achievements in previous positions as Chief Coordinator and Head of Department LLM Program Goa University. Proposed and set up a self-funded integrated 5-year LLB course and restructured the 3-year course, introduced an internal assessment component. Entrance exams were introduced by him in both courses and many more. And he has done 12 students have completed PhD under him. He is a member of Executive Council, Academic Council, University Code, Research Conferment Committee, BOS in Law of Goa University. Member of Task Force of National Human Rights Commission, and he has held many more positions. Thank you, sir. We are glad to have with us such a great personality. Now, I would like to introduce today's chief speaker, Professor Mark Brown, sir. He completed his Bachelor of Arts from University of Delaware in 1990. In 2001, he completed his Juris Doctorate University of Idaho College of Law. In April 2003, he became member of Oregon State Bar. From March to May 2014, he was a Fulbright Specialist Grant recipient. From 2003 to 2010, he was an adjunct professor, Washington State University, Vancouver. In 2004, he became attorney. From 2005 till present, he is a deputy public defender, parole coordinator, chief deputy defender. He also has done various publications and presentations like presenter at Oregon State Bar Criminal Law CLE April 2009, presenter at Mexican Criminal Procedures CLE July 2009, and many more. As the list is too long, I am also glad, sir, to you being with us in this webinar. I would also like to introduce Advocate Rashekar Malushte sir, organizing secretary of this program, who is always there with us and ready to help us at any time. He was a lawyer for last 28 years, law teacher for last 23 years, out of which 10 years as in charge principal. At present, he is a law teacher at the Victor Dantas Law College, Kudal. Thank you, sir. Thank you all of you for joining us and giving your valuable time. I am glad we are having with us such eminent personalities. Now I request today's chief guest, Professor Dr. Pinero sir, to express his few words. Hello.
Hello, am
Yeah,
I
Pinaro
audible?
sir. Yes, sir, you are
Yeah.
audible.
Okay. First of all, a very happy Dasara to each and everyone, those who are participating in this seminar.
Thank you,
Uh,
sir.
Let me begin with
Thank you, sir.
a very good morning to Professor Mark Brown. As he mentioned earlier, it is very early in the morning in US, and the weather
Yeah.
is extremely cold, I believe. Well, some years back, I had experienced that cold when I was in UK around this time. The I would like to also thank Dr. Vivek Duptale for deeming it fit to invite me for this program. Yeah, yeah.
Yes.
To begin with, the topic today, as already mentioned, is that basically the problem is that of discrimination. Discrimination as such is a global issue. Every nation has its own problems of discrimination, and India also has not one or two but many problems relating to discrimination. Professor Dubdale was able to mention a few of his personal experience, but the discrimination that exists in India goes much beyond that. It has got the historical complexes, caste dimensions, and things like that. But this program is not meant to discuss the discrimination that happens in India. So let us come back to the topic. It is regarding the discrimination that happens in the USA. Basically, the discrimination of the black people by the white-skinned people of USA. Now, this topic aptly has been titled nowadays as Black Life Matters because that is a major issue and it is a human rights issue. Coming to USA in terms of history, I would say, though I am not offending anybody, that USA is basically a country of migrants, except for the Red Indians, whom we call Red Indians, who are the native inhabitants or natives of the American continent. All others who are presently and who were there in America or USA are basically migrants from different part of the world, mostly from Europe, who have migrated to USA, the New World, for various reasons at different times in the history. Though the white-skinned Europeans claim that they were the first to migrate, the only purpose for which they migrated was for their economic well-being and security for the future. Absolutely nothing else. Europe those days was getting stagnated and overpopulated, and these people in the United Kingdom, Spain, France, Italy, Portugal, etc., felt that the only way to secure a better future for them and their children is to migrate to the new world. They are more or less, I would call them the runaway people of Europe. Now, when they reached this new world, they found that the land is plenty, but they needed workers, laborers, to work in their fields and their farms. And that is where the slave trade from Africa began. Though it is impossible to give an accurate estimate on figures, some historians have estimated that nearly 6 to 7 million enslaved people are imported to the New World during the 18th century alone, depriving the African continent of some of its healthiest and ablest men and women. Looking at the situation in retrospect, one finds that Africa was then a land of plenty, plenty of natural resources, plenty of wildlife, and of course, the food which they are cultivating or they were getting from the forest. But unlike the Europeans of those days, those Africans were not greedy for wealth. The Africans, by and large, were a self-contented population who loved and respected nature and was content with what they had Though the Europe described Africa as an underdeveloped and a poor nation, because in their eyes, there were no industries, there were no pollution, there were no surplus of trade with other countries. But Africa by itself was self-sufficient and a contented population. The young and healthy Africans were compelled to travel to the American continent as slaves by intimidation and physical violence against their own will. In modern parlance, one would call it as terrorism. These African nationals did not come to the American continent by their own free will. But the whole production of agriculture and industry, what we call the Americans' wealth creation, took place because of the efforts of these black-skinned Africans. When Abraham Lincoln issued the Emancipation Proclamation on June 19, 1865, popularly known as the Second Independence Day, these black Americans did not receive a fair deal, and they had to start from ground zero. When their white counterparts were already in a very rich and well-to-do position with good education and well-settled economic activities. This lacuna created a gap, I would say a wide gap, between the white Americans and the black African Americans. During the last 3 centuries, these gaps have only widened, creating the present-day state of discrimination and the resulting violence. In my personal opinion, if the black Africans were given enough opportunity to prosper, and if the so-called American prosperity was equitably distributed, the situation of tension and maltreatment would not have arisen. If the governments of America, I mean the various state governments, were to ensure at least equal quality of education and an opportunity to participate in the process of economic development, there would have been economic equality to some extent over a period of time. But unfortunately, this does not happen. And that is the situation that we are facing now. The vast gap in the economic prosperity, in the educational level, I believe has led to this particular kind of situation that is existing in USA presently, and now that has been titled as Black Life Matters. It's basically, as I mentioned earlier, a very, very concern for human rights. I personally don't have much knowledge about the actual ground realities of USA, and that is why we have an expert, Professor Mark Brown, who has been in and the thick of things regarding this issue to espouse to us the realities of the situation and possible alternatives. With these few words, I would like to wish Professor Mark Brown, though he's feeling very cold and chill there, all the best. And I hope you will be able to enthuse the participants with your knowledgeable presentation. I would also like to thank the Shivaji University for giving me this opportunity. I hope, Professor Duptale, I have not exceeded the time that is given to me. Thank you very much.
Thank you, sir. Okay. Now I request today's chief speaker, Professor Mark Brown, sir, to guide us on today's topic.
Thank you.
Mark Brown, sir.
Thank you, Dr. Dupale,
thank you,
and Dr. Bagati, and welcome to Chief Guest Dr. Pinero, and for your very insightful analysis of the topic we'll be talking about today. And namaskar kolhapar, me Professor Mark Brown, tumha sarv kolhapar, karana mashi namaskar, mala katri ahi ki tumi sarvik asal, tumha sarvana miyaha kadun dasyachi Ani Deepwalachi Hardik Subhecha. And
Thank
I
you.
apologize for...
No, it's okay. That was wonderful. You did well, sir.
Hi, sir.
and
Thank
I
you for your
apologize for any issues with pronunciation. And I am Mark Brown, coming to you from the United States. And I do request that people mute their microphones. And if you have questions, you could put them in the chat box, and Dr. Dupali will read them to me. So when I was asked to do this, and again, thank you for inviting me, I realized the topic is fascinating to me, but I also realized I agreed to talk about 400 years of history in 2 hours or less, which is quite a bit of information, as you can imagine. As I started working on the presentation, I realized that I could probably do a whole semester course on this topic. So by necessity, this will be a very broad overview of the topic and go into a little details here and there, but really kind of move through quickly. But I do encourage questions, and afterwards we will have a question and answer discussion session. So actually, I am going to now share my screen with a presentation. Hopefully this will work okay. And let's move things around briefly. There we go, let's do that. And excellent, hopefully everyone can see that. And move this over here. And so the title is From 1619 to Black Lives Matter, 400 Years of Racial Discrimination in the United States of America. So as I said, a very large topic we're talking about here. And let's see, there we go. So I'm coming to you from Portland, Oregon. You can see the map of the United States and the black arrow pointing to approximately where I am, where it is still morning here, just barely getting light here this morning. And as you're told, I am an attorney. I'm an appellate public defender, which means that I represent people who cannot afford an attorney who have been convicted of a criminal offense and are now appealing to the Oregon Court of Appeals or the Oregon Supreme Court, to the state court systems. It's very important work. I do really like the work. I like representing people and ensuring their rights are honored in the process. I am also sometimes a professor. I did have the honor to teach at Shivaji University, Department of Law in December of 2017. It was an excellent experience. I enjoyed my time. My wife and I enjoyed the time we spent in India. We traveled around Rajasthan for a few weeks before coming to Kolhapur, and did really enjoy the people, the hospitality, and just the culture of that region. As I said, I live in Portland, Oregon, and I'm coming to you, as I've been telling people, from my pandemic bunker. The one thing that's actually, if we want to find a bright spot in the whole pandemic, is that people have gotten more used to sitting in front of computers for presentations. And so it's been a great opportunity to have these types of presentations where people from around the world can attend. Let's see, there we go. So the topic is the history of racial discrimination from 1619 to Black Lives Matter. And here's just some slides of some images. Starting from the top left corner and going clockwise, we have a photograph of sharecroppers, probably in the early 1900s, probably freed slaves. Abraham Lincoln, the president who freed the slaves. Frederick Douglass, who himself was born a slave and later became an important writer on slavery and an advisor to President Lincoln at one point. Below Frederick Douglass, we have Thurgood Marshall, who we'll talk about as we proceed into this presentation. He was instrumental as an attorney for fighting some of these civil rights issues in the 1950s and 1960s, and then later was the first African-American Black Supreme Court justice on the United States Supreme Court. Next to Thurgood Marshall is Rosa Parks. Rosa Parks is famous for the Montgomery bus boycott, where she refused to sit in the bus behind the white people in the Black section and got arrested for it, which led to the bus boycott and led to big protests, which actually did in many ways lead to the changes in the civil rights movement. On the bottom left, we have an image from Black Lives Matter that we'll talk about towards the end. Above that image is Harriet Tubman, and Harriet Tubman is known for organizing and famous for organizing the Underground Railroad, where she helped shuttle free or escaped slaves from the South to the North and into Canada, where they could be free. And in the middle is a very sad sketch of a slave auction, where probably a mother is being separated from her daughter in the slave trade. So just some quick images of what we're going to be talking about. So when I came to India in 2017, the topic was comparing the United States Constitution and the Indian Constitution. And so I read through the Indian Constitution several times and read about it when I was preparing. And it's a very long constitution. But I really got interested in the Equal Protection Clause of the Indian Constitution, because as I learned, the Indian Constitution borrowed from a lot of different constitutions around the world. And one article that was borrowed in part from the US Constitution, or the US Constitution was used as a model, was the Equal Protection Clause. And here is the Indian Constitution, Article 14. The state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. And below it is the Equal Protection Clause of the 14th Amendment of the United States Constitution. No state shall make or enforce any law which shall deny any persons within its jurisdiction the equal protection of the laws. So very similar each of them are very similar, but that's sort of where they diverge. Here's Article 15 of the Indian Constitution. The state shall not discriminate against any citizen on the grounds only of religion, race, caste, sex, place of birth, or any of them. No citizen shall, on the grounds only of religion, race, caste, sex, place of birth, or any of them, be subjected to any disability, liability, or restriction, or any condition regard to access to shops, public restaurants, hotels, and places of public entertainment, or the use of wells, tanks, bathing ghats, roads, and other places, or other place of public resort maintained wholly or partly out of state funds or dedicated for the use of the general public. So the drafters of the Indian Constitution went further than the United States Constitution. Dr. Ambedkar, and excuse my pronunciation, as we know, was a Dalit, and he understood that simply declaring that everyone was equal was not enough. And the chief guest mentioned this at the beginning, that it's not enough to just simply say everyone is equal after years of inequality. There has to be kind of affirmative steps taken to ensure equality. And so he understood that one group that has been oppressed for hundreds of years, that group needs a step up to become equal. And Article 15 was in part that step up. It continues that nothing in this article shall prevent the state from making any special provisions for women or children, and nothing in this article or in clause 2 of Article 29 shall prevent the state from making any special provisions for the advancement of any socially and educationally backward classes of citizens, or for the scheduled castes and the scheduled tribes. So that is critical, I think, to the difference between the Indian Constitution, equal protection, and the US Constitution, and that the Indian Constitution understood that there has to be special provisions in education, special provisions in employment, in accessing power, in becoming part of government and employment. These all need to be special accommodations for those who have historically been cut out from those areas. And again, continuing, looking at Article 15, the rest of Article 15, again, doesn't prevent the state from making any special provisions for the advancement of the socially and educationally backward classes of citizens, for the scheduled caste or the scheduled tribes, relating to the admission of educational institutions. So the importance of education was really understood by the drafters of the Equal Protection Clause of the Indian Constitution. And turning to Article 16, it has a provision to allow for the reservation of appointments to posts in favor of the backward classes of citizens. So saying that nothing in the Equal Protection article or in the Constitution shall prevent appointments or posts that favor any backward classes of citizens, which are not adequately represented. So the government is able to, in India, say, okay, we need more representation of this group of people so we can make accommodations for that. In the US government, that is not the case. And in fact, as we'll see, that's been fought against for many, many years. And then Article 17 was very interesting to me when I was studying the Indian Constitution, because it abolished untouchability. So untouchability is abolished and its practice in any form is forbidden. The enforcement of any disability arising out of untouchability shall be an offense punishable in accordance with the law. So outright abolished, whereas if we look at the 13th Amendment to the United States Constitution, the 13th Amendment abolished slavery. It was written after the during the Civil War, actually. And it says, neither slavery nor involuntary servitude, except as punishment for a crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. So the Article 17 of the Indian Constitution abolished untouchability, no exceptions, whereas the 13th Amendment to the United States Constitution said there shall not be slavery or involuntary servitude except as a punishment for a crime where the person's been duly convicted. So there is an exception clause in the 13th Amendment. And as we'll see later in the presentation, that becomes very important. And that's a very important difference between the Indian Constitution protections and the protections in the United States Constitution. So again, it did become really interesting to me. This is where I started thinking about the differences between equal protection in the United States and India, and really did lead up to this presentation. So a few moments on terms. So as we're looking at cases today, and there were cases in the reading material from the United States Supreme Court, among other materials, there's a number of different terms that are used for Black Americans. And I just wanted to touch on them because they are interchangeable, but they're from different periods of time. So the term Negro was 19th and earliest 20th century term. So it was used in the 1800s to early 1900s. The term colored was really used from the 1940s to the 1970s, was the common term for Black people in the United States. In the 1980s and 1990s, the term Black became a common usage for referring to Black people in the United States, followed by African American in the mid 1990s. All of these had their controversies. All of the terms were controversial in their own way. Today, it seems like we're moving back to the term Black to refer to the Black people of the United States. Also on the top right, you'll see BIPOC, which is a very new term, which you may see in the news now and again. And that stands for Black, Indigenous, and Peoples of Color. So it's a more inclusive term to include the Native Americans, the Indigenous people, as well as other peoples of color, so Hispanics, among others. So as we use terms interchangeably, those are ones that you'll see. So in part, we're talking about African Americans, but really the first question is, what is white? I mean, who is a white person, and what does that mean? And I think that's important to understand when talking about this topic. Is white simply not Black? Is it if you're not Black, you're white, or is Black simply you're not white? And again, I think historically in the United States, we've followed what's called the one-drop rule, meaning that if a person's ancestry has a Black person in it, a Black ancestor, they're considered Black. Now they may, look white, and they may ultimately everyone consider them white, but historically in the law, they would be considered Black. So that means, for example, if one of your great-grandparents was Black, you'd be considered Black. Many other countries had different classifications of people with percentages of their ancestors who are Black. They had actually different terms for depending on how many of your ancestors were Black and how far back it goes. For example, in South America and the Caribbean, these classifications were quite complex, and they really showed where you stood in society. But in the United States, again, if you had any ancestry who was Black, you'd be considered Black. So as I was thinking about what is white, I came upon this definition after reading quite a bit. White is an exclusive club with many privileges in which the members decide who belongs and who does not. And there's a definition that I put together. It's not out of any official documentation. But white is a social construct to project superiority of one group over another. So one group declares that they are superior over another because of their skin color, and they will decide who belongs to that club. And really, in the early days of the United States, that club, those who belonged to the club had ancestry, came from Germany, Northern Europe, and the such. So Germanic, Nordic, and Gaelic were essentially what would be considered white originally. Interestingly, Irish were not considered white. So Northern Europeans were considered white. But up until the early 1900s, Southern and Eastern Europeans were really not considered white. They were considered sometimes ethnic whites, sometimes whites other. In fact, my family came to the United States in the late 1800s, so about 1893, from Eastern Europe. Probably my family was not considered white at that time. They were considered ethnic of some sort. But the club expands. So in order for the club to keep a majority, the club has been expanded over time. So the members of the club decide at some way that, okay, we will consider this other group that's been excluded, we will include them now. So my family, the Eastern Europeans and Southern Europeans were included into the club of white. And remember, white is a social construct to protect the superiority of one group over another. So most of what we will look at today was implemented to keep the social hierarchy based on skin color in place. That's been sort of this whole process to make sure that the social hierarchy exists, and that is what leads to the tensions and protests of today, is that the social hierarchy is still with us. So I want to turn to a case to start off with to talk a little bit about this club of whiteness that exists in the United States, looking at a case that I hope will be of interest to our guests from India, or in India. United States v. Bhagat Singh Thind. It's a 1923 case. So Mr. Thind, as a young man in the early 1900s, came to the United States to study transcendentalist philosophy. He was fairly well educated. He was of the educated caste. He attended college in San Francisco, and he worked summers in a logging camp in Oregon. So there is actually a connection to my state. And he actually enlisted in the U.S. Army and fought in World War I in Europe. So he was a World War I veteran. And Mr. Thind wanted to become a citizen of the United States, and he applied for citizenship, and he was actually granted citizenship by the Oregon courts, but then the United States government challenged that decision, and it went to the United States Supreme Court to determine whether the Oregon court made a mistake in allowing him to become a citizen. So as the Supreme Court said in its opinion to describe Mr. Thind is a high caste Hindu of full Indian blood, born at Amritsar, Punjab, India, a white person within the meaning of section, is he a white person in the meaning of section 2169 revised statutes? So, I mean, of course, those of you in India have kind of said, wait a minute, he looks like he's Sikh and not Hindu. So is the Supreme Court wrong? And in fact, at that time, and I looked into that because I also realized that, and the term Hindu was used to describe anyone from the Indian subcontinent. So even though Mr. Thind was a Sikh, he was referred to as Hindu as sort of his race, as opposed to Indian. So section 2169 of the revised statutes at that time provided that the provisions of the Naturalization Act shall apply to aliens being free white persons and to aliens of African nativity and to persons of African descent. So at that time, the only people who could become US citizens were those who were free white persons and Africans and those of African descent. So if you didn't fall into one of those categories, you could not become a citizen. You couldn't even apply for citizenship. And it was a time of great xenophobia in the United States, very much trying to keep the United States a white country. So then one thing that interested me was to see that it included African nativity and to persons of African descent. And I did a little research on how that came about. And that came about during Reconstruction, which we'll look at in a little bit, when there was actually quite a few people of African descent in the government. And that is when that provision was put into the Naturalization Act. But Mr. Thind argued to the US Supreme Court that he was white because white is Caucasian. Caucasian is generally referred to, or a term used to describe white. And he argued that his ancestors came from the Caucasus, that his ancestors migrated to the Punjab region from what was historically the Caucasus region. And so therefore, he was Caucasian and met the term white person and should be allowed to become a citizen. In a previous court decision, an earlier case from the US Supreme Court a few years earlier, Ozawa of the United States, a person who was born in Japan, Mr. Ozawa, but lived in the US for many years, tried to become a US citizen. His argument, Mr. Ozawa's argument, was that his skin tone was very light, and he therefore could be considered white, that he was really as white as anyone in the United States. The court in the Ozawa decision said, no, he doesn't meet that description because white refers to Caucasian. And that's a scientific classification. Caucasian is scientific and it means the ancestry from the Caucasus region. And clearly he was not from that. He was what was referred to as Mongoloid at that time, or from East Asia. And so the court said that Mr. Ozawa in that earlier case could not be a US citizen because he was not Caucasian. So then Mr. Thin said, wait a minute, my family is in fact from, my ancestors are in fact from the Caucasus, from Caucasian region, therefore we are Caucasian and we should be, and I should be considered white. The court said, well, wait a minute. The words of familiar speech, which were used by the original framers of the law, were intended to include only the type of man who they knew as white. So the court said, yeah, we did say that in the last opinion, but what we meant was that those who were writing this law back when they were writing it, they knew what white was, and white was what they considered to be white and not anything else. And so the court went on, what if any person of primarily Asiatic stock come within the words of the section, we do not deem it necessary now to decide. There is much in the origin and historic development of the statute to suggest that no Asiatic whatever was included. So essentially Asians need not apply. So although the court acknowledged that in the deep past, some people of the Indian subcontinent came from what is now considered the Caucasus, those people so intermixed with other people that they were no longer Caucasian. That again, they're not considered white. So the court continued, what we now hold is that the words free white people are words of common speech to be interpreted in accordance with the understanding of the common man, synonymous with the word Caucasian, only as that word is popularly understood. As so understood and used, whatever may be the speculations of the ethnologist, it does not include the body of people whom Apelli belongs. It is a matter of familiar observation and knowledge that the physical group characteristics of the Hindus, again, using Hindus to refer to the people of the Indian subcontinent, render them readily distinguishable from the various groups of persons in this country commonly recognized as white. So the court held that a person is white if we say they're white. Again, this is an exclusive club in which the members decide who belongs and who doesn't belong, who gets the benefits of being in the club and who does not. So essentially the court said, we know it when we see it. So even though they had previously in the Ozawa case said Caucasian is a specific scientific term and that means white, here they're saying, yeah, well, white means what we say it means. And if we think you're white, you'll be white. If we don't think you're white, then you're not white. And so Mr. Thind was denied citizenship at that time. The Supreme Court said he could not become a citizen. There's a picture of Mr. Thind in his later years. He did eventually become a US citizen in 1935 when Congress passed a law that made all World War I veterans eligible to become citizens regardless of their race. So he did become a citizen in 1935. He later earned his PhD in theology and English literature from University of California in Berkeley. And for many years, he gave lectures and wrote many books on metaphysics and the Sikh religious philosophy. There's a lot of books that he published. You can go online and there's a whole website about his philosophy. So again, showing that white is this exclusive club that means what the white people say it means at any given time. In 2004, scientists published a draft of the human genome. This is a kind of graphic representation of the human genome. I'm not sure exactly how accurate it is, but it looks all scientific-y, so I put it on there. But one of the things that came out of the mapping of the human genome is finally to state with scientific certainty that race is not genetic. Excuse me. Again, I'll repeat that race is not genetic. There's no genetic component to race. Race is a social construct. It's something that society creates, not that is created through genetics or science. So the genome of a person born in India, a person born in Kenya, a person born in Mumbai, and a person born in Tokyo are the same. So it proved once and for all that race is a social construct used to divide people and created to divide people, and nothing more than that. And that is something really critical to remember as we go through the rest of the presentation, that race is a social construct and has no basis in science. So we're going to step back for a minute and give you the 5-second lecture on federalism. So the United States has a federalist government structure, and this is confusing to many people who are not in the United States. In the United States, the individual states are the sovereign governments. So the individual states created the national government. The states got together and agreed to give certain of their sovereign powers to a national government. So for example, the power in commerce, the power to regulate commerce, the power to regulate coinage of money, to regulate the post office, are powers that that state governments gave to the national government, but the state governments retained all powers not expressly given to the national government. So the national government is one of limited enumerated powers. And what that means is Article 1, Section 8 lists specific powers of the national government. Congress shall do this, Congress has the power to do that. But if that power isn't included on the list, it remains within the powers of the states. And one of those powers is what we refer to as the police powers of the states. And police power sounds like law enforcement, but it's actually the power over the health, safety, and education of the state citizens. So the state of Oregon, for example, where I live, has the power to control education within the state. So it makes up its rules to control its education. The national government does not control the state's education. Also, one area that confuses many people who are not familiar with this federal system is criminal law. So there may be a crime, something may be a crime in Oregon where I live, but if I traveled, say 20 miles north to Washington state, a different state, it would not be a crime. So crimes in many cases are determined by the different states. And there's also the Commerce Clause, or the Necessary and Proper Clause, and the Commerce Clause, which we'll see later on come into play to expand the powers of the national government. So keep that in mind when we're talking about the national government and the state governments. They're two separate governments, and the state governments are actually independent governments from the national government, which now after what we're now 50 minutes into the presentation, we're finally getting to the story that we came to talk about, which is the history of Black racism or racism against Blacks in the United States. So we start with Jamestown, Virginia in 1619. And this is a painting of that time. Jamestown, Virginia, it was the first British settlement in North America. In August of 1619, English pirates who had captured a Portuguese ship with 20 to 30 African slaves landed in Jamestown. The pirates then sold the slaves to the settlers in Jamestown and started a 250-year history of enslavement of humans in the United States, in North America and the United States. So historically, slavery existed in many parts of the world, including Africa. Africans enslaved other Africans historically, but usually That was the result of conquest. So one tribe conquested another tribe, and they took slaves from that tribe. They took people and enslaved them from that tribe. But one difference is the descendants of those enslaved people were not slaves. So generally, they became citizens of the country. So once when they were born free. And that's generally, historically, how slavery worked throughout history. But Europeans never conquered West Africa, where the enslaved peoples came from. There was never a conquest. It was basically kidnapping individuals and bringing them to what's now the United States and other countries throughout the world. This was essentially seen as commerce, the trade of goods, except that the goods and trade were human beings. So it wasn't part of conquest, it was part of commerce. And the key departure from history, again, is that the descendants of the enslaved people in the United States also became enslaved. So your descendants continued to be slaves. And that was a very different than historically slavery had been used and seen around the world historically. So one myth is that slavery existed only in the southern states. And a fact is that slavery was legal in all 13 colonies at the time of the Declaration of Independence. So you could see the dates where slavery was abolished. So interestingly enough, we're not taught that in school. In school, I was taught that the southern states were the slave states and northern states were not the slave states. And again, the reality was not only did the northern states have slavery at the time of independence, even after northern states abolished slavery, many northerners still participated in the slave trade. So many northern ship owners use their ships to transport slaves from Africa to the United States. And northern manufacturing profited from slavery through inexpensive raw materials, especially cotton for textile mills in the north. So the north had industry. A lot of the industry was textile mills making textiles. And they got the cotton from the south, which was inexpensive because of the slave trade. So even though the North had abolished slavery, the North still benefited and profited from slavery. And there was vast amounts of wealth that was created by the enslaved peoples, some of which remains today. Some old money in some families can be traced back to the slave trade and slavery. So we turn to the Declaration of Independence, written by Thomas Jefferson, who is pictured here. And the portion that I quoted, which is the portion that most everyone has heard, we hold these truths to be self-evident that all men are created equal, that they are endowed by their Creator with certain unalienable rights. Among these are life, liberty, and the pursuit of happiness. That was from the Declaration of Independence, written by Thomas Jefferson. Thomas Jefferson owned approximately 130 humans, enslaved them when he wrote that passage. He also had children with one of his slaves, Sally Hemings, and he enslaved his own children that were from Sally Hemings. So, one of the big questions that comes up all the time in the United States is, how do you reconcile Thomas Jefferson as a slaveholder and Jefferson as a proponent of human rights, that all men are created equal and endowed by their Creator with certain unalienable rights? So how is that reconciled? And it may be that it's not reconcilable. It may be that people are just very complex and we can't reconcile different aspects of their life. But one theory is that Jefferson, when referred to all men, did not recognize people from Africa as humans. At that time, there was a quote unquote scientific theory, had no basis in science, that Africans were actually a different species, that they were not humans as we are, as white people are. That theory never had any base in science. There's also a biblical theory that Africans were the darker son of Noah, who was banished from society. So many popular theories that may have led to Jefferson being able to write that and believing that to be true. And so that when he was referring to all men, he was referring to all men of Northern European heritage. But I mean, we'll never know. There's no writings. Interestingly, in an early draft of the Declaration of Independence, so the Declaration of Independence has a list of grievances against the English government, against the king, to explain why the US was declaring independence. And one of those in an early draft was that the king has put upon us this darkness of slavery. And that was later removed. So Jefferson was, in his early draft, talking about the evils of slavery, but it was removed in a later draft. So it's also important to note that it wasn't just Jefferson. Of the 56 individuals who signed the Declaration of Independence, 41 of them were slaveholders. So think about that. 41 people who signed the Declaration of Independence, a majority of people who signed the Declaration of Independence owned human beings. And yet they signed something that said, we hold these truths to be self-evident, that all men are created equal, that they are endowed by their creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. So quick, moving through history, the Articles of Confederation was the first document that created the United States. It was written in 1777, and it was then ratified in 1781, and it was replaced by the Constitution in 1789. It essentially created a very loose confederation of states with a very, very weak national government. And the legality of slaves was left up to the states. It wasn't even mentioned in the Articles of Confederation because it was seen as a state power, and so the national government had nothing to do with it. But the Articles of Confederation essentially failed and was replaced by the Constitution. The Constitution was ratified in 1789, and by the time of ratification, all the northern states had abolished slavery except New York and New Jersey. So the northern states at that time, for the majority, were no longer slave states. And in fact, there was a strong abolition movement growing in those states. New York and New Jersey had not yet abolished slavery, but they were on their way. And it was just a matter of, a short period of time until they would abolish slavery. Although, interestingly, in researching this, I discovered that New York and New Jersey abolished slavery, but people who owned slaves could keep their enslaved people until those people died. So it didn't free already enslaved people. So slavery, actually, there were enslaved people in New York until the 1830s, from what I researched. So at the writing of the Constitution, there was this strong tension between northern states and southern states. And they really came out in three areas of the Constitution: representation in government, taxes, and slavery. And we'll see the compromises that were made. So Article 1, Section 2, Clause 3 of the United States Constitution talks about representation in government and direct taxes, so representatives in the House of Representatives and Congress. So Congress is divided into two houses. There's the Senate, and the Senate has 2 members of each state are elected to serve in the Senate. So the Senate has 50 individuals, 2 from each state. The House of Representatives is based on population. So the more people in a state, the larger the number of representatives in the House of Representatives in Congress. And so, and that itself was a compromise. So Article 1, Section 2, Clause 3 deals with how you calculate representatives. So representatives and direct taxes shall be apportioned among the several states which may be included within this union according to their representative numbers, which shall be determined by adding to the whole number of free persons including those bound to service for a term of years, so indentured servants, and excluding Indians not taxed. There's a whole other presentation on that. And 3/5 of all other persons. So, as I said, the House of Representatives is based on population. So, for example, in the Senate, California, which has a very large population, has 2 senators, and Wyoming, which has a very small population, has 2 senators. But in the House of Representatives, California has 53 representatives and Wyoming has 1. So the southern states wanted to count enslaved human beings for that purpose as one person. The northern states said, wait a minute, no, you can't do that, because you're saying on the one hand that enslaved persons are property, but now you're telling us that you want them counted as humans for your representation. So it's all about power. The southern states knew that if they could count all of the enslaved persons as humans, as persons for representation, they would have a much larger representation in the House of Representatives. The northern states said, no, they don't count. You can't count your property. If you consider them property, you can't count them as a person. So there was a compromise. It's called the 3/5 compromise. So the enslaved peoples were counted as 3/5 of a person. So not full persons, but not as nothing. And you know, it has really it was important in those early days for representation in government. Article 1, Section 9, Clause 1 has another compromise. The migration or importation of such persons as any of the states now existing shall think proper to admit shall not be prohibited by Congress prior to the year 1808, but a tax or duty may be imposed on such importation not exceeding $10 per person. So that prohibited after 1808 the importation of humans for slavery. But it actually didn't ban slavery. It actually added to the profits of the Southerners. So the Northerners were generally working in the slave trade. They had the ships. They were transporting individuals from Africa to the US. But the Southerners, if no more slaves were coming into the country, if no more enslaved people were coming into the country, their slaves became more valuable in trade. So that actually benefited the Southerners to end the importation of enslaved people, but still allow for the slave trade within the United States. And then the third critical compromise to bring the South and the North together in writing the Constitution and agreeing to the Constitution is Article 4, Section 2, Clause 3. No person held in service or labor in one state under the laws thereof escaping into another shall in consequence of any law or regulation therein be discharged from such service or labor, but shall be delivered up on claim of the party to whom such service or labor may be due. So even if a slave escapes to the North, to a non-slave state, they are still considered a slave. And if they are captured and delivered back to their owner, they are still enslaved. And so this, the abolitionists in the North didn't want this in the Constitution because they wanted a situation where if a person escapes to the North, they become a free person because they left slave states, and the Southerners would not stand for that. So this compromise came about. And this led to a whole industry of bounty hunters who would be sent to the North to retrieve freed slaves, which is again why I had mentioned earlier, the Underground Railroad brought escaped slaves to Canada where they could not be brought back to the South. So the Underground Railroad essentially was a system, a network of locations where people could be moved from South to North and into Canada. and hidden along the way. So they were traveled along back roads, and they were hidden many times in churches and other houses along the way. So the United States, of course, was the Constitution was passed, and we had our government structure that we have now, which is the three branches of government: the executive branch, the legislative branch, and the judicial branch. One shocking fact that, again, we're not really taught in our country is that of the 10 of the first 12 presidents of the United States owned humans. So George Washington, Thomas Jefferson, James Madison, James Monroe, Andrew Jackson, among others, were all slave owners. So in school, we briefly learned that Washington and Jefferson owned humans, but really just in passing. When I was growing up, it wasn't really anything that was emphasized. But we are just not taught that of the first 12 presidents, 10 of them were slave owners. And in fact, we're also not taught that, or we weren't taught when I was being taught, that the White House, the picture on the top, the presidential house, was built by slave labor, as was the Capitol building where Congress sits, was also built by slave labor. So, you know, if you're a young Black student learning American history, you learn that these buildings that are iconic buildings in the United States were built possibly by your ancestors being enslaved. Indeed, if you go to Washington, D.C., two of the more prominent memorials are the Washington Memorial and the Jefferson Memorial, both of which are memorials to founders of the United States who were also slave owners. So again, we have this kind of difficulty in our history where we have these great individuals who are, you know, iconics to the American history, but also enslaved human beings. And again, people are flawed, but it's something, again, as if you were a young African-American or young Black student who was in Washington, D.C., you'd see these monuments to people who enslaved your ancestors. Indeed, our money has slaveholders. And so again, putting yourself in place of a Black child who's taught that George Washington and Andrew Jackson enslaved humans, and then you see their picture on your money or their monument. So there's these constant reminders that, you know, those who owned slaves are still seen as heroes and icons in this country. So as we proceed through US history, we have a series of compromises, again, to keep the US together, because there was this growing tension between the northern states, which were becoming more and more anti-slavery, pro-abolition of slavery, in the southern states, which were relying more and more on enslaved human beings for their economy. So as the US began to expand westward, again, taking land from the indigenous people, again, but that's a different lecture entirely, an effort was made to keep the balance between slave states and free states, because if the balance tipped one way or tipped to the north, then it could have been, there could have been laws that outlawed slavery, including constitutional amendments. If it tipped to the south, there could have been constitutional amendments to guarantee slavery. So the Missouri Compromise of 1820 brought in Maine. You can see on the top right, there's a blue arrow, Maine as a free state, and brought in Missouri as a slave state. It also created a line, the Missouri Compromise line. You can see where Arkansas Territory is. There's a line just above that. Any state that came in after this above that line would be a free state. Any state below that line would be a slave state, although that later was abolished in a later compromise. So then we move to the Compromise of 1850, and this compromise is often called Popular Sovereignty Compromise. So when a state was created, the people in that state can vote whether to allow slavery. It also retained the Missouri Compromise line. So at this point, you can see the slave states in yellow, the green states are the free states, and several territories to the west. The territories that were purple were open to slavery by popular sovereignty. So when a state was created out of those territories, it could vote, the people in that state could vote to have slavery or not. And then the green are free states and territories, although that will could potentially change. So that was a compromise of 1850. Again, these were compromises to keep the nation together because that was the goal of the government, of the national government. So the Kansas-Nebraska Act of 1854, so 4 years after the last compromise, you can see these compromises are getting harder and harder to keep. The Kansas-Nebraska Compromise created two new territories, the Kansas Territory and the Nebraska Territory. You can see those are the two orange territories sort of in the center of the map. And it abolished the Missouri Compromise line. So it said that line doesn't exist. It allowed any states formed out of those territories, the Kansas-Nebraska Act, to vote on whether to allow slavery. And there was the potential for slavery in the North. So at that point, the territories that were in the North could vote for slavery if they became states. And so, for example, let's look at Oregon. Oregon was part of the Oregon Territory at the time of the Kansas-Nebraska Act. Oregon gained statehood in 1859, so before the war between the states. So there was still slavery in the United States. So Oregon had the option of voting whether to have slavery or not. And the people of Oregon voted to outlaw slavery. So slavery was banned in Oregon, but they also prohibited any blacks from settling in the state. So essentially it's like, okay, we're not gonna have slavery, but no black person can actually live in Oregon. They could come to work briefly, but they had to leave after a certain amount of time. So in many ways, and looking at the history, Oregon was created originally as this haven for whites, that it was going to be this white state that blacks wouldn't be allowed in either as slaves or free people. The point of this history is to show that during much of the early history of the United States, the first basically almost 100 years, it was influenced by the struggle between free states in the North and slave states in the South, really created how the U.S. government and the U.S. evolved in the struggle between free states and slave states. And so each state could decide whether to become a slave state or not, which actually brings us to our first case, although we could stop if there's any questions that have been submitted from this point back. Have there been any questions submitted? Okay, well, we can.
We have a question from More, sir, Dr. More. He's asking whether there is any, he's Professor, Sri Krishna and More is asking, do you think that slavery and untouchability is still
I'm having trouble.
How would you like to compare slavery and untouchability in the present context?
Okay, I didn't hear.
Did you get the question?
I didn't hear the question.
Okay, I'll repeat it. I'll repeat it again. He says, untouchability. Do you think that slavery and untouchability still exist? How would you like to compare slavery and untouchability in the present context?
slavery and I didn't hear the compare.
Untouchability,
Untouchability.
which is prohibited
yeah.
in
Slavery and untouchability. You know, I don't know really enough about the history of untouchability to answer that. I mean, I don't know. You know, I know that the untouchables at that time were outside of the caste system and were given the most undesirable tasks and were often not allowed to participate in most aspects of society. But I don't know the details enough to really answer that question. You know, the enslaved people were they were told, you know, you this is what you will do. We won't pay you. You didn't get paid. You had no choice in the matter. So I don't know. I think there's definitely parallels, but I don't know enough about untouchability to really answer that question.
Okay, sir. Okay, please continue, sir. Please
Okay, great. Sorry about that. Again, I
It's
don't,
okay. The
don't
question
like
was
to delve into areas I don't know enough about.
yeah, the
So
question-
we're going to start looking at some of the cases. So Dred Scott v. Sanford. This is before the Civil War. This is when slavery was still legal. It was an 1857 case. I see I wrote 1957. It is 1857. So that's an error on my part. So in Dred Scott, again, it was 2 years before Oregon became a state and 3 years after the Kansas-Nebraska Compromise. So Mr. Scott was an enslaved person. His owner traveled to a northern state with Mr. Scott, and Mr. Scott escaped from his owner and declared himself free under the laws of that state. And under those laws, once an enslaved person escaped to the state, they became a citizen of the state with all the rights and privileges of that state. So Mr. Scott, by escaping from his owner within that state, became a citizen of that state automatically. And then he said that I'm a free person. His owner brought a lawsuit to get his property back, to get Mr. Scott back. He said that Mr. Scott is property and the state cannot take my property without compensating me. So the court, in this Dred Scott opinion, and I'm going to spend a little bit of time on it because it's an important opinion, because it shows how the even the court system saw that slavery was something that should exist. The question is simply this: can a Negro whose ancestors were imported into this country and sold as slaves become a member of the political community formed and brought into existence by the Constitution of the United States, and as such become entitled to all rights and privileges and immunities guaranteed by the instrument of the citizen? One of which right is the privilege of suing in a court of the United States, in this case specified in the Constitution. So underlying the case was that Dred Scott then brought a lawsuit also saying that I am free and I want the court to declare that I'm free. So the question was, can he even bring a lawsuit in the United States courts? Does he have that privilege? And the court explained that previous to the adoption of the Constitution of the United States, every state had undoubted the right to confer on whomever it pleased the character of citizen and to endow him with all the rights. But this character, of course, was confined to the boundaries of the state and gave him no rights or privileges in other states beyond those secured to him by the laws of nations and the comity of states. So what that means is that a state could always grant citizenship for that state, but it only meant that the person had citizenship within that state. It did not carry to any other state. And so a state can grant rights and privileges under a state constitution and laws, but not under the US Constitution and laws. So consequently, no state since the adoption of the Constitution can, by naturalizing an alien, invest him with the rights and privileges secured to a citizen of a state under the federal government, although so far as a state alone is concerned, he would undoubtedly be entitled to the rights of a citizen and clothed with all the rights and immunities with which the Constitution and laws of the United States or the state attaches to that character. It is very clear, therefore, that no state can, by any act of law or law of its own passed since the adoption of the Constitution, introduce a new member into the political community created by the Constitution of the United States. So if you remember early on, I talked about how the states gave up certain rights to the national government and retained the rest. One of the rights given up by the states was the right to determine who becomes a citizen. So only the national government could determine who became a citizen of the United States. So the court said, okay, a state can create state citizenship, but not national citizenship because it gave that right up. And so the court continued, they had for more than a century before been regarded as beings, the slaves, enslaved peoples, beings of an inferior order and altogether unfit to associate with the white race, either in social or political relations, and so far inferior that they had no rights which the white man was bound to respect, and that the Negro might justify and lawfully be reduced to slavery for his benefit. He was bought and sold and treated as an ordinary article of merchandise and traffic whenever a profit could be made by it. This opinion was at the time fixed and universal in the civilized portion of the white race. That's actually not true. There was a very strong abolition movement throughout the country, and many countries throughout the world had abolished slavery by that point. So that was an incorrect statement. It was regarded as an axiom in morals as well as in politics, which no one thought of disputing or supposed to be open to dispute, and men in every grade and position in society daily and habitually acted upon it, their privilege, their private pursuits, as well as in matters of public concern, without doubting for a moment the correctness of the opinion. So this is where the court starts kind of playing with history a little bit and saying, this is just an accepted reality, when in fact, at this point, again, 1857, most countries had abolished slavery. And in fact, there was in the northern states a strong abolition movement. So the court was misrepresenting the history in order to reach its conclusion. And accordingly, a Negro of the African race was regarded by them as an article of property and held and bought and sold as such in every one of the 13 colonies which united the Declaration of Independence and afterward formed the Constitution of the United States. The slaves were more or less numerous in the different colonies, as slave labor was found more or less profitable, but no one seemed to have doubted the correctness of the prevailing opinion at the time. Again, that is not correct. There was a lot of questioning, even at the time of the Constitution, whether to have slavery or not.
Professor
And the
Mark,
court, yes.
I would like to interrupt a little bit. If you need to take a break in between,
Okay.
we can have a discussion. You can have a break, and we will have a discussion with other resource person on the what we have already discussed till now. You can quickly take one break and come
Okay,
back.
maybe I will take a break in a little while.
If you wish, whenever you
Thank
want.
you.
Yeah, whenever you want.
Thank you.
Yeah. Okay, sir.
So
Please continue.
again, the court, looking back at the history, looks to the Declaration of Independence and said, Declaration of Independence stated that we hold these truths to be self-evident, that all men are created equal, endowed by their creator with certain unalienable rights, among those life, liberty, and the pursuit of happiness. So the court quoted the Declaration of Independence and then stated the general words above quoted would seem to embrace the whole human family, and if they were used in a similar instrument at this day, would be so understood. But it is too clear for dispute that the enslaved African race were not intended to be included, and form no part of the people who framed and adopted this declaration for if the language as understood in the day would embrace them, the conduct of the distinguished men who framed the Declaration of Independence would have been utterly and flagrantly inconsistent with the principles they asserted, and instead of the sympathy of mankind to which they so confidently appealed, they would have deserved and received universal rebuke and reprobation. So the court's using the Declaration of Independence and the fact that the drafters owned slaves against the slaves and saying this is what was understood at the time. And it was understood that the rights did not apply. And so the court even noted that the Constitution acknowledged that inferiority in separate people, that the Constitution had these clauses that we just looked at that acknowledged that there was slavery was permitted, and that enslaved people were considered 3/5 of a person. So the court concluded, and these two provisions show conclusively that neither the description of persons therein referred to, nor their descendants were embraced in any of the provisions of the Constitution. For certainly these two clauses were not intended to confer on them their posterity blessings of liberty or any of the personal rights so carefully provided for the citizens. So essentially the court said, the African slaves, the enslaved persons, were not considered persons under the Constitution. And that is what Dred Scott is notorious for, basically saying that, holding that the US Supreme Court holding that Mr. Scott, that enslaved peoples in the United States were not people for purposes of human rights. And then there was a war. There was the Civil War, the war between the states, between the Union and the Confederacy. So and it was inevitable that war would happen. I mean, as we saw from the first days of the Constitution, there were compromises on top of compromises on top of compromises. So there was going to be a war at some point, a fissure, and the Southern states declared their independence and formed the Confederacy of States. The blue states that you see on the map are the northern states. The yellow states are the southern states. And the pink states in the middle are states that were slave states, but sided with the North. And there's, a question about whether the war was about slavery or was about simply states' rights. After the Civil War, the southern states kind of recast the war as a war about states' rights, but it was about slavery. And it was always about slavery. And I'm not going to go into details about the war. It went on from 1861 to 1865. The Emancipation Proclamation was announced by President Lincoln on September 22nd of 1862. And it was really more symbolic than effective. So the proclamation declared that all persons held as slaves within the rebellious states are and henceforth shall be free. And it took effect on January 1st of 1863. But it applied only to states that had seceded from the United States, leaving slavery untouched in the loyal border states. So again, it declared that all persons within the rebellious states, all enslaved persons in the rebellious states shall be freed. So it also expressly exempted parts of the Confederacy, the southern states, that had already come under Northern control. So really, it didn't free anyone, essentially, because if you remember, we have the kind of purplish states, which are the ones that were northern, sided with the North, but had slaves, and they got to keep their slaves. Their slaves were not emancipated by the Emancipation Proclamation. But it also announced the acceptance of Black men into the Union Army and Navy, which led to many regiments of formerly enslaved people fighting for the North. And the North won, and ultimately the Union was stitched back together. There were 3 amendments to the U.S. Constitution, the Civil War amendments. They were after the Civil War. The most important, or they're all very important, actually. I shouldn't say the most important, but the 13th Amendment to the United States Constitution abolished slavery. And we looked at this at the very beginning, comparing it to the article in the Indian Constitution abolishing untouchability. And as we saw, neither slavery nor involuntary servitude, except as punishment for a crime whereof the parties shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. So again, it outlawed slavery in the United States unless a person has been convicted of a crime. And again, we'll see how this plays out later on in this as we go through the history. The 14th Amendment was passed or ratified in 1868. And the first section overturned the Dred Scott decision. So the first section said that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state where they reside. So that created citizenship for any freed enslaved person, became a citizen automatically. Because they were born in the what's the United States. And no state shall make or enforce any law that shall abridge the privileges and immunities of the citizens of the United States. Privileges and immunities are essentially rights. Nor shall any state deprive any person of life, liberty, or property without due process of law. So you cannot basically re-enslave someone without due process of the law, take away their liberty. Nor deny any person within its jurisdiction the equal protection of the laws. So now we have an equal protection clause coming back or being first introduced in the US Constitution. If you remember, the Declaration of Independence said all men are created equal, but then the Constitution had nothing about equality. So finally, we have an equal protection clause that all persons within the United States have equal protection of the laws. Section 2 amends the part of the Constitution that said enslaved peoples count as 3/5 of a person. So now Section 2 of the 14th Amendment says representatives shall be apportioned among the several states according to their respective numbers, counting the whole number of persons in each state, excluding Indians not taxed. So it overruled Dred Scott, or rather, it amended the provision that counted slaves as 3/5 of a person. Section 3 is basically said that officials of the Confederacy are not permitted to hold any office in the United States. So basically, the white property owners of the South could not hold any offices of the United States, but Congress can remove such disability by vote. And in fact, they did not too many years later, basically around the 1870s. Most white Southerners got the right to hold office once again. And the 4th section simply said that debts of the United States from the war shall be paid, but debts incurred by the Southern states shall not be paid by the United States government. It also said that no claims for loss or emancipation, for loss of the emancipation of any enslaved person shall be allowed. So the 5th Amendment to the United States Constitution is known as the Takings Clause. It says if the government takes any of your property, you have the right to be compensated, or the government can't take your property without compensating you. This provision simply says that that no one can make a claim for the loss ensued by the emancipation of their slaves. So it makes an exception to the 5th Amendment Takings Clause. And the 15th Amendment was the last of the Civil War amendments, and says the rights of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. So the right to vote cannot be denied by race, color, previous condition of servitude, because voting is power. So if you can vote, you have power, and if you can't vote, you don't have power. So interesting to note that Black men, the freed enslaved people's men, had the right to vote 50 years before white women had the right to vote. So white women didn't get the right to vote until 1920, as opposed to Black men who got the right to vote in 1870. Over the next 100 years, as we'll see, many states required poll taxes, literacy tests, and other tests in order to vote. So they really did put up as many blocks they could, and said that these were not prohibited by the 15th Amendment, but because they were not on account of race, color, or previous condition of servitude. They were just certain requirements, like the person could read and write. And it was not until the Voting Rights Act of 1965 that any effort was made by the federal government to ensure that everyone could vote. Which actually will bring us to an interesting but brief, unfortunate period in the United States history, this post-Civil War period, which is known as a period of Reconstruction. And during the period of Reconstruction, an effort was made by Congress through a series of laws to empower formerly enslaved persons. So at the conclusion of the war, there was approximately 4 million enslaved people that were freed. And Congress at that time wanted to empower the freed enslaved peoples, much like we saw in the Indian Constitution, provide for opportunities for the formerly enslaved people. So Congress passed a series of laws to reorganize the southern states and extend the fundamental principle of equality under the law to Blacks. And remember that Section 3 of the 14th Amendment said that anyone who swore an oath to support the US Constitution and then engaged in insurrection and rebellion against the United States shall not hold any civil or military office in the United States. And so that essentially left mostly formerly enslaved people to hold civil offices in the South. So the Military Reconstruction Act of 1867 created 5 military districts in the South and gave military officers a power to oversee provisional state governments and purge the electoral rolls of anyone who had aided the Confederate cause. And it also required, the Reconstruction Act also required the Southern states to ratify the 13th and 14th Amendments for readmission into the United States. Another thing that it did was to redistribute land. So it took land from the plantation owners and sought to redistribute that land to the freed enslaved people or formerly enslaved people. And that was, it's commonly referred to as 40 acres and a mule, because the former slaves were supposed to each get 40 acres and a mule. The military had a lot of mules, so they would give them a mule. Unfortunately, that never really happened. And there was some land distributed, but then after Reconstruction, it was reclaimed, it was taken back by the government, and the people who had been working the land lost their land. So the Reconstruction era really did look to empower the freed slaves, give them land, give them opportunities, give them a chance to participate in government. And here's several of the important civil rights era legislation. The Civil Rights Act of 1866 established citizenship for all persons born in the United States of every race and color, without regard to any previous condition of slavery or servitude. And the law granted full and equal benefits of all previously limited, the equal benefits to all laws previously limited to white citizens. So Blacks are granted equal protection under the law, under the Civil Rights Act of 1866. The Civil Rights Act of 1870 prohibited the denial of the right to vote based on race, color, or previous servitude. So again, enforcing the 15th Amendment. The Civil Rights Act of 1871 made it a federal crime for any person to form an unlawful combination to deprive any other person of their constitutional rights. Such was considered a rebellion against the government of the United States. So what that means is, and that was targeted at the Ku Klux Klan and other groups that were forming to attack the freed slaves. That was seen as rebellion against the government of the United States. And finally, the Civil Rights Act of 1875 banned discrimination in public accommodation. So restaurants, hotels, any transportation and so forth was banned, that you could not discriminate based on race in public accommodations. But unfortunately, the Reconstruction era did not last very long. By 1876, only 3 states remained under Republican control. The Republicans, at that time, the Republicans were the ones who were pushing for Reconstruction. So the Democrats were the ones who were pro-slavery before the Civil War, and were basically the party of the white plantation owners, the white slave owners. But the Republicans lost control of southern states. And in the presidential election of 1876, which was between Rutherford Hayes, a Republican, and Sam Tilden, a Democrat, turned on disputed election results from those 3 states, from the 3 southern states that remained under Republican control. After some negotiations between the northern and southern political leaders, it led to a compromise, yet another compromise. Under that provision, under that compromise, Hayes, a Democrat, would become president. So the Republican would become president of the and would recognize Democratic control of the remaining southern states. The Democrats would not block certification of his election to Congress. So essentially, it said that, the compromise was that those white people who were the former plantation owners and former enslavers would come back to power and would get their power back. It's interesting to note that the South was solidly Democrat until the 1960s. So for nearly 100 years after the Civil War, and that's ultimately when the Republicans convinced the white Southerners that the Democrats wanted to pass laws that would ensure civil rights and voting for Blacks. So we'll see that later on, how that shift occurred. But the Republican Party took control of the South, only many 100 years later. But we get ahead of ourselves there. The civil rights cases in 1883, which we'll look at briefly at some point, invalidated the Civil Rights Act of 1875. So the Civil Rights Act of 1875, if you remember, is the one that said you cannot discriminate based on race in public accommodations. In 1883, the US Supreme Court said that the wrongful act of an individual unsupported by any government authority is simply a private wrong. So the Supreme Court held that private discrimination cannot be enforced or deemed illegal by the US government because it does not have the power that falls within the state police powers. So the Reconstruction era survived for maybe 15 years. And in that time, the Blacks, the freed slaves, did make some ground. They got some power in government, they got some opportunities, but those were quickly taken away from them after the Civil War, after the Reconstruction era ended because of that compromise. And that leads us to the rise of Jim Crow. And, towards the end of Reconstruction, local governments again began to pass laws to keep the races separate because now you have the whites back in power. So what is Jim Crow? You may have heard that name. The origin of the name is mostly lost in time. There's a number of different theories. There was a well-known performer at the time who performed in blackface, so a white person who performed in blackface, who called himself Jim Crow. So that may be the origins of it. In fact, there's also a story that he was a black man who performed in blackface. So a number of different stories around there. But what Jim Crow was, the Jim Crow era, was there were local laws that were designed to reestablish the hierarchy with whites as a dominant group and blacks as a subservient group. Again, we saw the post-Civil War constitutional amendments and the laws that were passed at that time looking to equalize the blacks and the whites and to make them the same and not have this historic hierarchy. Jim Crow, under these local laws under Jim Crow, sought to reestablish that hierarchy. It forced many formerly enslaved people to become sharecroppers, again, where they grew crops, mostly cotton and tobacco, on the land of the former plantations on which they worked as slaves, and they usually worked for their former slave owners. So how sharecropping worked is that a person was allowed to farm property on this plantation, and they had to give a certain portion of their crop to the landowner. And then they got to keep what was left. So it wasn't that much different than slavery. And at this time, many of the states passed laws that required the separation of blacks and whites. So separation throughout society. So first laws involved train cars. So trains were becoming a main mode of transportation at that time. And laws that said, there were white cars and black cars, and the blacks could only travel in the black cars and the whites were in the white cars. But soon, these laws encompassed every aspect of society. So for example, in hotels, public restrooms, trains, buses, restaurants, public pools, and public schools all were separated between the races. So again, it's important to note, and I said this at the beginning, that in the United States, unlike the rest of the world, there was no kind of recognition of mixed race. You're either black or you were white, and there was no mixing, whereas many places in the world, there was a lot of different categories of people of mixed race. In the US, we had the one drop rule again, which was if you had one drop of African blood, if any of your ancestors were freed slaves, then you were considered black. And it's again important to recall that race is a social construct to keep one race in power over another race. And so this is again using that social construct to keep those inequities, to keep the hierarchy in place that had historically been in place. And I think that's a good time for a break.
Yeah. Can you take up one question, if you permit me?
Sure.
Yeah, it's from Sayantan Roy. He says, what is your opinion on the movement after death of George Floyd in USA?
What's my view on the death of George Floyd? I'll get to that. That's sort of where we'll end up with the whole presentation. So stay tuned for that.
Yeah, sure. Thank you.
And
yeah.
I can stop sharing for a moment, and now we can take a little bit of a break. How long of a break?
How long do you want?
We can take a 5-minute break.
Okay, no problem, sir. 5 minutes.
Great.
So the participants, we are going on a break for 5 minutes, and we'll be joining after 5 minutes. Please don't go away. If you want, you can have a discussion with our other resource persons, Professor Dr. Marian Pinero or Advocate Modeste sir, or we can have a discussion amongst us if you wish to have. But please don't ask anything about America. Yeah. Hello. Are there any questions? or do you want to discuss on any point of discussion that we have already had? Anything you want to share, your own views, you can have, we can share it. Hello?
Something about untouchability, sir?
Yes, please. Yeah. So, yeah.
Yes. There was a question from one participant,
Right.
and Professor Dr. Mark Brown, sir, was very candid on saying that he was not aware of the Indian scenario on that point. He was
Yeah.
very sincere on that. I appreciate that.
Sure. Yeah.
Many of us know, and it is for the benefit of those who do not know, especially Dr. Brown, sir,
Yeah.
that untouchability in India was based on the Varna system, as Dubdale sir had begun it in a nutshell. As a beginning, there were the 4 Varnas, and these Varnas were sort of caste system. There were 2 superior castes. The third one was the Kshatriyas, they were the warriors, and the fourth was a group of persons who were, I can say, a bit deprived in the society at that time, and they were compelled to do some work which the others would not do. That is cleaning the things and all those things which the other elite, so-called, they would not appreciate to do that, and therefore they were looked down upon, and they were actually the servers. They were the serving people of the society, but yet they were looked down upon. And there was the practice of untouchability, that they were called the Kshudras initially, but it was Mahatma Gandhi who gave them the name that the children of God, and therefore they were called as Harijans. They were the children of God. And then Mahatma Gandhi ji was the first in India who gave a view that they should not be discriminated against. Moreover, they were very important for the cleanliness and for the unity of the society, a sort of. They worked for the society. Their work was selfless. And as we move towards the Constitution of India, towards the independence and post-independence period, at the time of formation of the Constitution of India, we had that very much important article in the Constitution which laid down a mandate that the practice of untouchability will be abolished. And I'm very happy, and Dr. Dubdale sir, also I would appreciate your efforts that you have been doing for creating awareness amongst the people around Shivaji University territory, that is Kolhapur and the nearby districts. Wherever Kolhapur, Shivaji University, wherever it can spread, you are doing very well, sir. I appreciate that, for legal awareness. Through legal awareness and through the awareness about the constitutional aspects, we can show to the people, especially in the rural area, there are little bit of that practice of untouchability in a clandestine manner seems to be there in a little bit manner. But by and large, I'm very happy to tell that throughout India, the then practice of untouchability has been abolished to a larger extent. I can say to the extent of 95% it has been abolished. And there are other laws in place as well to help that constitutional mandate. And they are the Protection of Civil Rights Act on one side. And there are also the Prevention of Atrocities on the Scheduled Castes and Scheduled Tribes brethren. So I'm very happy that in India we have achieved that goal of removal or eradication of the untouchability system. But still we should not be complacent. There are some pockets where rights are being tried to be practiced. And I feel that awareness amongst the people about their rights, awareness of the responsibility of the remaining people to honor those rights will surely pave a good way towards having a united society without any, without any discrimination, without any divisions. As Dr. Ravindranath Tagore had said, we should not have any divisive walls in between. And that goal is on the way of being achieved fully. But there are, of course, some limitations, and with the help of Dr. Pinario, Dr. Dubdale, the achievements of awareness that we can have, I am sure that the next generation students, the next generation citizens will have. Let me share with you one on this point. When we used to be as a children of students of school, we used to go to the hotel, and there used to be a board that this hotel is for all castes and creed people. This hotel is permissible to be used by people of all castes and creed. Today we don't find such boards. Even I was when I read that board first time, I was asking somebody why at all this board has been placed in a hotel. It was a rule at that time, because at that time we were on that midway. We had not totally abolished, but we were on the midway. And today we are very proud Indians to say that such boards are no more required. When we meet somebody, we don't ask him what is his caste. We look at him as a personality. We look about his hygiene, his approach towards the society, and the brother colleagues, the brother human beings. I think with this I have made a point about removal of untouchability to the larger extent in India. But Dr. Brown sir has very nicely and elaborately thrown light on the comparative study even on these aspects about the constitutional law in India and the constitutional law in the United States. I thank you, sir. Thank you, sir, Dugdale sir, for the nice opportunity.
Yeah, thank you. We have Chief Resource Person on the line now. I request him to please continue. Thank you.
Okay, we're back, and thank you for a little touching on the area of untouchability, which, as I noted, I am not as familiar with. I'm just going to start slideshow again. There we go. Hopefully everyone can see that. And that is really interesting, because what we're seeing now, as I was saying in the early part, comparing the two constitutions, in the Indian constitution, there is that very specific, the important recognition that there have to be opportunities given and provided for in education especially, but also in government service for people who historically have been subjugated by the majority. And what we saw in the US is we had 250 years of enslaving individuals, and then they were freed. And for a brief period of time, there were laws that said they have to be provided equal opportunities. So not giving them opportunities, specifically granting them opportunities to bring them up to give them the advantages that they'd been deprived, but simply to say, okay, we're all equal now. And I think as we now go through the next section, we'll see that was the major flaw in the United States, in that you can't just simply say, okay, everyone's equal now, when you've had this historic inequity. Which brings us again to Jim Crow and sort of Jim Crow in action. As I said, Jim Crow is kind of the loose term for this kind of panoply of laws that discriminated based on race. And again, remember, and I keep coming back to this, race is a social construct. There's nothing genetic, nothing scientific about race. It's simply a social construct in order to keep people subjugated and keep other people in power. So here's some pictures, Jim Crow pictures. Public swimming pools are for whites only. Drinking fountains, one for whites and one for what was referred to as colored people. Specific waiting rooms and trains for colored people. So that's Jim Crow in action. But this is also Jim Crow in action. So Jim Crow was also a violent suppression of African Americans, of Blacks, of individuals who were historically subjugated. And anytime that they tried to get power, to make them, to force the government to recognize them as equal, they were put down either through fear or through force, or sometimes through both, through lynchings, through the military, the Ku Klux Klan, which you could see on the top right, ways to keep the classes separated and to subjugate one group over another based on race. Which brings us to Plessy v. Ferguson. And Plessy v. Ferguson is an 1896 case that the United States Supreme Court decided. And it's one that is no longer good law, but it's an important case to look at to understand what came afterwards. So in Plessy v. Ferguson, you had Homer Plessy, who lived in New Orleans, Louisiana. And he wanted to challenge, and a group wanted to challenge the legality of having separate train cars. So train cars for Blacks only and train cars for whites only. Mr. Plessy was considered Black. Again, we had the one drop rule, but he passed, in quotes, meaning that he looked white and he could move through society and people would believe he was white. But he was legally considered Black. And so this was a test case. He agreed to ride the train for a short distance in the white car. And he let everyone know that he was doing this. It wasn't, you know, they wanted, those who were testing the law wanted this to be known, which is how you test laws sometimes. And shortly after the train left, it was stopped and he was removed and arrested for violating the law that said he was Black, he had to be in the black car. And he was convicted of violating the law against Blacks riding in the white car, which led to this case, ultimately testing the constitutionality of that law. And so the Louisiana law required train cars for Black and white passengers. So here's what the law said. All railway companies carrying passengers in their coaches in this state shall provide equal but separate accommodations for the white and colored races by providing 2 or more passenger coaches for each passenger train, or by dividing the passenger coach by partition so as to secure separate accommodations, provided that this section shall not be construed to apply to street railroads. No person or persons shall be permitted to occupy seats in coaches other than the ones assigned to them on account of the race they belong to. So the law said that the railroad companies shall provide equal but separate accommodations. So the question is, what does it mean to be an equal car? So is the purpose of a train car, if it's just to get from point A to point B, then equality is, well, this train car gets you from point A to point B, that train car gets you from point A to point B. Yes, one train car may have plush seats and food service and chandeliers, and the other one may have hard seats with no food and no lights. But if they get you from point A to point B, are they equal? Or is equality more than that, more than just getting from point A to point B? And that's, you know, what a lot of these cases turn on. What does equal mean and what are we looking for? Again, we have the one drop rule. I keep coming back to that, but that's important for all of these cases, that in the United States during the Jim Crow era, a person with a Black ancestor is considered Black. So even though Mr. Plessy looked white, he was considered, in the eyes of the law, Black. So the question before the court was, does the Louisiana Railway Act of 1890 violate either the 13th Amendment prohibiting slavery or the 14th Amendment, which prohibits certain restrictive legislation on the part of the states? So the arguments that were made were both that this was an aspect of slavery because it created different classes of people, and that the court rejected pretty quickly. The court said that it does not conflict with the 13th Amendment, which abolished slavery and involuntary servitude, except as punishment for crime is too clear for argument. Slavery implies involuntary servitude, a state of bondage, the ownership of mankind as a chattel, or at least the control of labor and services of one man for the benefit of another, and the absence of a legal right at the disposal of his person, property, or services. So the court said this isn't in violation of the 13th Amendment because it's not slavery. And then the court continued by explaining that laws permitting and even requiring that there's separation in places where they're liable to be brought into contact do not necessarily imply the inferiority of either race to the other, and have been generally, if not universally, recognized as within the competency of the state legislatures in their exercise of their police powers. Again, police powers are those powers over kind of health, safety, education that are retained by the states. The most common instance of this is connected with the establishment of separate schools for white and colored children, which have been held to be valid exercises of the legislative powers, even by courts of states where the political rights of the colored race have been longest and most earnestly enforced. So the court's saying that separating races does not imply one race is inferior and one is superior. It just simply says that they are separated, and the state police powers are able to do that. That falls within the state police powers. The court continued, the argument also assumes that social prejudices may be overcome by legislation and that the equal rights cannot secure to the Negro except as enforced commingling of the two races, except by an enforced commingling of the two races. We cannot accept this proposition. If the races are to meet upon terms of social equality, it must and the voluntary consent of the individuals. Legislation is powerless to eradicate racial instincts or to abolish distinctions based upon physical differences, and the attempt to do so can only result in accentuating the difficulties of the present situation. That passage, when I read that the other day, actually reminded me of what people talked about when I was in India. How, and I think this was touched on earlier, how we can legally abolish involuntary servitude or say that everyone is equal, but that doesn't mean that everyone's going to accept that. And the big issue is, how do you get society to accept equality, even if it is legally required? And that's what the court's saying here. If the civil and political rights of both races be equal, one cannot be inferior to the other civilly or politically. If one race be inferior to the other socially, the Constitution of the United States cannot put them upon the same plane. So what the court is saying is that, you know, separation doesn't mean that one is superior to the other. It just means that they're being separated. And if there is the societal superiority and inferiority, the Constitution can't get at that, and the laws of the United States cannot get at that. That is up to society. So legislation cannot force races to live together. And if civil and political rights are equal, then how can one be inferior to the other? So the court's viewing it as, well, there's one train car, there's another train car, they both get you from point A to point B, therefore they are equal. So one is not superior than the other. But Plessy v. Ferguson is known for creating the separate but equal doctrine. The separate but equal doctrine says that it's not unconstitutional to separate individuals by race as long as there are equal opportunities. So you can separate people in train cars as long as there's equal train cars, or you could separate students in schools so long as both of the students are getting, the separated students are getting educated. So again, the court took a very kind of narrow view of what equality is. Equality is simply having having something that is the same. So you have train car A and train car B. Train car A, again, might have plush seats and a chandelier. Train car B might have hard seats and no lighting, but they're equal because they get you from point A to point B. Or a school may, you know, the white school may have extracurricular programs and sports and buses and excellent resources. The black school may have poor resources, no electricity, no indoor plumbing, no books or anything, but because it's a school, there's a school for blacks and there's a school for whites, so therefore they're equal in the eyes of the court in Plessy v. Ferguson. And so that is essentially the doctrine that was in place from the 1890s until essentially the 1960s, which we'll see. And in the 1930s, a group was formed, the National Association for the Advancement of Colored People. And this organization was formed to push for laws and push court cases to ensure equality of the colored people to whites, to get rid of the social hierarchy. And one person who is critical for this period of time is, as I said earlier, Thurgood Marshall. Thurgood Marshall was the head of the Legal Defense Fund for the National Association of Advancement of Colored People. What that meant was he led up the litigation to get rid of the separate but equal doctrine, to bring equal rights to everyone. And Thurgood Marshall, as I said, was the second director of the Legal Defense Fund. His long-term strategy was to attack separate but equal from all directions until it was gone. So not make a direct attack right away, but to chip away at it over time. And he also, like I said, served as the first US Supreme Court, the first Black US Supreme Court justice. He was a Supreme Court justice from 1967 to 1981. So Thurgood Marshall is critical to this period. But one aspect of racial discrimination was in housing in the US. So, and this discrimination was just as common in the North as in the South. In fact, it was probably more common in the North. And it's commonly known as redlining. So redlining was where the real estate brokers in a city all agreed that they would literally draw a red line around an area where blacks and other minorities could live. So those were the areas that were designated where non-whites could live, and everywhere else was reserved for white people. And so the real estate agents agreed not to sell to black families outside of those neighborhoods. And it's in many cases, the banks would not lend to blacks to buy houses in white parts of town. So it was really all these businesses getting together and relegating blacks to one part of town. There was also restrictive covenants that we'll look at in a moment. But so here's an advertisement from that time for new houses. But you can see where there's code to it, where it's not specifically said that this is for whites only, but anyone at this time reading this would see, you can see where it's boxed, where I have the red box, that it's below Catherine Street in the new restricted section. So they don't mention race, but everyone reading that would know that if you're black, you would not be able to buy a house in this new area. But if you're white, you can move there and it would be an exclusively white neighborhood. So that's what's known as redlining. There are also these restrictive covenants, and that was another way to keep blacks and minorities out of certain neighborhoods. A covenant in property transactions is simply a condition written into the property transaction, into the deed. So for example, a deed may say the house shall be painted white, or only specific trees can be planted on the property, or that the property can only be used for non-commercial purposes. These are all common covenants that restrict the use of property. And when you purchase property, you understand that there's these covenants that you're agreeing to by purchasing it. But there were these racial covenants, restrictive covenants, that provided that the owner agreed not to sell the property to blacks or other racial or religious groups. So here's a racial covenant, restrictive covenant from that time. None of the said lands, interest therein, or improvements therein shall be sold or resold, conveyed, leased, rented, or in any way used, occupied, or acquired by any persons of Negro blood or to any persons of the Semitic race, blood, or origin, which racial description shall be deemed to include Armenians, Jews, Hebrews, Persians, and Syrians. So specifically, look that anyone selling that house could not sell to any of those individuals. This brings us to Shelley v. Kramer. And in Shelley v. Kramer, you had the Shelley family, you could see on the right, that just wanted a decent place to rear their children. And Thurgood Marshall saw a challenge to race-based covenants as a way to challenge Jim Crow, one aspect of Jim Crow. J.D. Shelley was a World War II veteran, and he used the money that he had saved up while in the Army to buy a house for his family. And you can see a picture of the house on the left. It wasn't a hugely fancy house, but it was a house that his family could call their own. However, after he purchased the house, he was told that the sale was void because there was a racial covenant on the deed that said the owner could not sell to a Black family. So therefore, the deed was void, or the transaction was void. And with the help of the NAACP Legal Defense Fund, he challenged the racial covenant, said that that is in violation of the Constitution. And the problem, so the court in Shelley v. Kramer stated that these cases prevent for our consideration questions relating to the validity of court enforcement of private agreements, generally described as restrictive covenants, which have as their purpose the exclusion of persons of designated race or color from the ownership or occupancy of real property. So the problem under the 14th Amendment is that it says no state shall deny any person equal protection of the law. For the 14th Amendment to apply, there must be a state actor. So in other words, it must be the government that is denying the protections. If you remember, I mentioned quickly in the civil rights cases of 1883, the court said that a private wrong is just a private wrong and the government has no control over it. So here, the state, the individuals who are fighting the Shelleys said that, said that there was no state actor here, that the racial covenant was simply an agreement between two people. And so therefore there's no constitutional violation, no equal protection violation. And the specific restricted covenant here was that the said property is hereby restricted to the use and occupancy for said term of 50 years, occupied by any person not of the Caucasian race, it being intended hereby to restrict the use of said property for said period of time against the occupancy as owners or tenants of any portion of said property for resident or other purposes by people of the Negro or Mongoloid race. So that's a specific restriction that was on the deed in this case. So a restrictive covenant, may simply, excuse me, may simply say that property can only be used as a residence or house, but cannot be taller than a certain height. So again, there can be restrictive covenants that aren't racial. The court said that it should be observed that these covenants do not seek to prescribe any particular use of the affected property. Use of the properties for residential occupancy as such is not forbidden. The restriction of these agreements rather are directed toward a designated class of persons and seek to determine who may and may not own or make use of the property for residential purposes. The excluded class is defined wholly in terms of race or color. So unlike those other covenants, this one is specifically about race or color. And again, the 14th Amendment says that no state shall make any law denying equal protection. So again, we have arguably no state actor here. The court said that it is likewise clear that restrictions on the right of occupancy of the sort can be created by the private agreements in these cases could not be squared with the requirements of the 14th Amendment. So again, if this was a case where there was a state law or even a local law that said, a Black person could not buy this house. That would clearly violate the 14th Amendment. But the problem here is that there's no state actor. But the court is wondering, is the state somehow involved? And the court noted that the principle has become firmly embedded in our Constitution law that the action inhibited by the first section of the 14th Amendment, that only such action may be fairly said to be that of the state. The amendment, again, erects no shield merely against private conduct, however discriminatory or wrong. But the court says we're called upon to consider whether the enforcement of the state courts of the restrictive agreement in these cases may be deemed the actions of the state. So again, a property right is only as good as how you can enforce it. So you can have a property right, but if you can't enforce it, then it doesn't mean anything. And how do you enforce a restrictive covenant? You do it through the court system, as was done here. You go to the courts and you say, courts, this restrictive covenant is being violated. And the Supreme Court says that we have no doubt that there has been state action in these cases in the full and complete sense of the phrase, essentially saying that when you have local courts enforcing restrictive covenant, that is a state actor. And but for the local courts enforcing this restrictive covenant, the Shelleys would be able to live in their house they purchased from a willing seller. So it's the state courts as the actor who is critical in this point. It is clear that but for the active intervention of the state courts, support by the full panoply of state power, petitioners would be free to occupy the properties without restraint. So without being able to get the restrictive covenant enforced, then it means nothing essentially. In other words, the court system is a state actor and is critical to the enforcement of the racial code. So the court ultimately held that the difference between the judicial enforcement and non-enforcement of the restrictive covenants is a difference to petitioners between being denied the right to property available to other members of the community and being accorded full enjoyment of those rights on equal footing. So the courts are state actors and the courts are critical in this enforcement. Therefore, the 14th Amendment was violated by these restrictive covenants. And here's just a copy of the Real Estate Board of Code of Ethics from that time. A realtor should never be instrumental in introducing into a neighborhood members of any race or nationality whose presence will clearly be detrimental to property values of that neighborhood. So again, emphasize that race is a social construct that is used to keep people apart and to declare one group superior and one group inferior. In 1968, the by law required equal protection in housing. And it also allows the government to sue private persons who discriminate in housing based on race. But you know, the history of this redlining still exists today. In any city you go into, there'll be areas of the city that are almost exclusively minority areas where Blacks and other minorities live, and others that are almost exclusively where whites live. And that is a legacy of this redlining. There was also the legacy of white flight after these changes occurred and whites were now able to move into Black neighborhoods, or Blacks were able to move into white neighborhoods rather. Many whites left the cities and moved into suburbs, and many neighborhoods shifted from traditionally white neighborhoods to Black neighborhoods. So even though the racial restrictions were lifted, it did not create equality in housing. And here's a picture of Ms. Shelley, who's reading the headline announcing her win. So moving ahead, I'm not going to highlight all the protests and other direct actions that helped end racial segregation in the country, and especially in the South. There were lots of sit-ins at lunch counters, bus boycotts, voter registration drives. And that was what I'm focusing on here is the law. As I said, there's much more that I could cover, and I see I'm already probably behind myself, so I'll start moving along a little quicker. But understand that this is just focused on kind of the legal aspect of racial discrimination as opposed to what was going on in society at the time with protests and counter-protests. But probably the most famous case of these series of racial discrimination cases is Brown v. Board of Education. And while the NAACP and others were fighting for redlining, to end redlining and housing discrimination in the courts, they were also fighting to end school segregation. So schools were segregated in many places, both in the North and the South, but mostly in the South. There was a well-used strategy to keep racial stratification disparities in education. So again, if you don't provide education, a child a good education, you don't provide opportunities. So if you educate a child, you open up many opportunities. And so if you provide substandard education to certain groups, those groups are never going to have the opportunities that other groups have at their reach. So in other words, education is key to equality, which again, the Indian Constitution realized when it said that, you know, there has to be specific opportunities given to those who have historically been the oppressed castes and classes. So in many slave states before the Civil War, when slavery was legal in southern states, it was actually illegal to educate slaves, to teach them how to read or write. And that's likely because if you teach them to read or write, you open up a world of thought to them. They can read different philosophies and they can communicate with each other better over long distances, which could lead to insurrection and revolt. So it was illegal to educate slaves. And then after the Civil War, education for many years was a private affair. There was not public schools. So once states started creating public schools in the early 1900s, they started with these segregated schools because they realized that if they're publicly run under the Constitution, they could not discriminate. They couldn't say we're just providing schools for public schools for whites, so they had to provide education for blacks as well. So they created separate schools, which had much fewer amenities. And so the history of, actually I'm going to go back one slide. Yep. So this history of chipping away at racial discrimination through education started with colleges. So there was a case before, it was actually about the same time Shelley v. Kramer came out, where the equal doctrine was applied to schools. The equal protected, separate but equal doctrine was applied to schools. So the court said that, you know, many years earlier that, you know, if schools are separate, as long as they're equal, they're okay. So the NAACP started off with a case where they found a person was allowed to attend a PhD program at a state university, but he was required to sit at his own table in the cafeteria and in the library and could only sit in the hallway outside the classroom during classes. And the NAACP successfully got the court to say that was not equal. So it didn't say that separate but equal was unconstitutional. It simply said that wasn't equal. They had to provide equal opportunities. Similarly, in another case, a Black individual wanted to go to law school, and he was told he couldn't because there was no Black law school. He sued and won. So then the University of Texas created a second law school, which basically had secondhand books and borrowed faculty, and was in a building that was not nearly as nice as the University of Texas Law School. the NAACP simply argued that the Black Law School did not have a law review or moot courts, and a degree from the Black Law School carried no prestige, and that it lacked the network of professional contacts. So therefore it was not equal. And the court agreed in this case, Sweat, Sweat v. Painter. The court said that it upheld the separate but equal doctrine, but simply said that this was not equal, that there had to be better facilities for it to be equal. So the NAACP had started to chip away from the doctrine in higher education. They realized that if they went straight for elementary and secondary schools, it would be a huge restructuring of society. So they started chipping away at the higher education and then moved to elementary and secondary schools in Brown v. Board of Education. And the issue here is, does segregation of children in public schools solely on the basis of race, even though the physical facilities and other tangible factors may be equal, deprive the children of the minority group of equal educational opportunity? So by this time, most of the schools were coming up to about equality. And so the NAACP realized it's really time to go after the separate but equal doctrine. So in their argument, the NAACP presented a study in which Black students were given a black and a white doll and asked which one they liked better. Majority of the Black children chose a white doll and explained that it was prettier and that they identified the white doll with good qualities. So the NAACP used that study to show that the separate educational system lowered the Black students' self-esteem and promoted a feeling of racial inferiority among Black students. So it wasn't anything physical that was unequal. It was simply how the students viewed themselves and their self-esteem. So as the court said, the plaintiffs contend that segregated public schools are not equal and cannot be made equal, and that hence they are deprived of equal protection of the laws. And the court said, today, education is perhaps the most important function of the state and local governments. Today, it is a principal instrument in awakening the child to cultural values and preparing him for later professional training and helping him adjust to normally to his environment. In these days, it is doubtful that any child may reasonably be expected to succeed in life if he is denied the opportunity of an education. Such an opportunity, where the state has undertaken to provide it, is a right which must be made available to all on equal terms. And the court incorporated the doll study into its opinion, as you can see with this slide, that it generates the feelings of inferiority to their status when they are separated. And ultimately, in a fairly short opinion, a unanimous opinion, the court struck down the separate but equal doctrine as applied to education. We conclude that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. And so although the decision was limited to an issue before it, the education system, it was written in a way to signal to the country that the days of separate but equal are over. The court actually never mentioned Plessy v. Ferguson, but effectively ended the separate but equal doctrine. So no more bathrooms segregated by race or public pools. In fact, many towns closed their public pools rather than having to integrate them. But what about public accommodations, restaurants, hotels, retail, private businesses? Because again, there's no state actor there. So we only have a private entity, say a hotel, discriminating, but there's no state law. And we'll see how that plays out shortly. But again, as I mentioned earlier, public education is a state police power. So decisions related to public education is a power that's retained by the states and not given to the national government. So in this decision, the court scheduled a second set of briefing and arguments to decide how to remedy this constitutional violation, because in many ways it's seen as a taking of state power, by the federal government telling the states how to run their education system. And there's also an understanding that it would be a great disruption in society. And then in the second opinion, a year later, the court ultimately held that school authorities have the primary responsibility for determining how to educate their students. And because of proximity to local conditions, the possibility to need further hearings, the court said it should be done on a local level. And the court said the burden rests on the schools to establish that more time is necessary in public interest, and that is consistent with good faith compliance to the earliest practicable date. So the court said that it had to be completed with all deliberate speed. And that would play out for many, many years. Here's a slide with the New York Times headline from that opinion. But ultimately, with all deliberate speed turned into any conceivable delay, because it was for many years that school systems fought any type of desegregation. One of the most famous incidents occurred in 1957 in Arkansas, but it wasn't the only such instance. The governor refused to follow the federal district court's order to integrate the Little Rock High School. So there was a federal court order said the high school must be desegregated by this date. The governor further commented that integration would lead to race mixing at social functions, permit love scenes and class plays featuring students of different races. So really kind of riling up the people. And the governor called out the National Guard to prevent integration. President Eisenhower then dispatched about 1,000 soldiers to protect the Black students attending the high school. So this started looking like you had, militaries about to attack each other over this. And fortunately, it didn't come to that. But for the rest of the school year, Black students were escorted to and from school by soldiers. And often they had crowds of white students and citizens yelling and taunting them. And that was what all deliberate speed looked like. And it went on for, like I said, for the full year, for the school year. In 1958, 7 Southern states passed laws or amended their state constitutions to prohibit integration, required or permitted the abolition of public schools, abolished compulsory school attendance, or authorized a sale of public schools to private entities. So essentially, a lot of states said, we're either requiring by law that there be no integration, or we're going to get out of the business of public education. This is when one part of this was creating a voucher system. So individuals pay taxes to support the public schools. The state government started saying, well, you can take your tax money if your child goes to a private school, and you can use your tax money to pay for private schools. And that was a way to allow for private schools, which could still discriminate because they were private, from to allow them to still have segregated schools, and then the public schools would just basically become the Black schools. Additionally, Congress came within one vote of passing a law that would take away the authority of federal courts to hear cases involving school integration. So this wasn't something that the Southern states were willing to allow easily. In the 1958 case, Cooper v. Aaron, the court responded to the states that passed laws and state constitutional amendments. In short, the constitutional rights of children not to be discriminated against in school admissions on grounds of race and color declared by this court in the Brown case can neither be nullified openly and directly by state legislators or state executives or judicial officers, nor nullified indirectly by them. So the court answered those laws by saying, you can't do that. The Constitution requires that you integrate your schools, and you can't look for ways to get around them. By 1960, 6 years after Brown was decided, there was no school integration in 5 Southern states. So 6 years after Brown, 5 states still had segregated schools. 1965 saw the Elementary and Secondary Act. So 11 years after the Brown decision, there was finally a law that said schools have to be integrated. It also allowed national government to withhold grant money to school districts that failed to integrate. So it took many years just to get 11 years just to get that bill. Then likewise, we move ahead to 1971. In 1971, the court was becoming much more conservative and was backing away from some of the early integration decisions. Ultimately, the court left it up at this point to the state and the public schools to determine the best policy in ways to desegregate their schools. To do this as an educational policy is within the broad discretion powers of the school authorities, absent a finding of constitutional violation. So ultimately, the US Supreme Court in 1971 is finally saying, you know, we're leaving it up to the local districts to deal with this. We are not going to micromanage. By 1973, schools in the South were actually far more integrated than schools in the North. So the South, only 28% of Black children, or close to 50% of Black children were attending integrated public schools in the South, whereas in the West and North, it was only 28%. So that has a lot to do with some of the settlement patterns that you had these historic redlining districts. So the families were segregated geographically. As also white flight to many of the suburbs, which were generally much whiter than the city. You could see Detroit numbers show how segregated Detroit was between the city and the suburbs. And finally, in 1995, so this has been going on for many years, the court ended really any court supervision of schools. In Missouri v. Jenkins, the ultimate inquiry is whether the school district has complied in good faith with the desegregation decree since it was entered, and whether the vestiges of past discrimination have been eliminated to the extent practicable. So by saying, you know, whatever is done is done. We are now throwing up our hands and saying we can't do more. So it went from all deliberate speed to the extent practicable. And to this day, schools are still.
Can we take up one question?
Sorry, I'll take questions at the end because I'm kind of wrapping up. So I'll be done in a few minutes.
That will be good.
So 1964 saw the Civil Rights Act, and 1965 saw the Voting Rights Act, both of which were laws that enforced the lack of discrimination in civil rights and voting. Here's some pictures of some of the activities at that time. You can see Martin Luther King on the top left, and Malcolm X, another leader at that time in the Black community, on the bottom. And then the slide on the right is the March on Washington. The March on Washington occurred in August 28th of 1963, and that's where Martin Luther King said his famous "I Have a Dream" speech. And here I'm just throwing this in to play to my audience. In 1959, Martin Luther King traveled to India, and he was quoted when he landed to say, "To other countries, I may go as a tourist, but to India, I come as a pilgrim." Martin Luther King had studied and incorporated much of Gandhi's teachings into his movement of nonviolent civil disobedience. So Martin Luther King was in many ways a student of Gandhi's teachings. So I wanted to put that connection there. If you remember, the Civil Rights Act of 1875 was struck down as being unconstitutional because Congress did not have the power. And this said that there could not be discrimination in public accommodations based on race. Civil rights cases, again, I noted this earlier, said that the national government did not have the authority under the Due Process Clause to get at private discrimination. It was only for state discrimination. The Civil Rights Act of 1964 did essentially the same thing, said that there could not be discrimination based on race in public accommodations. And it was challenged. It was challenged in two cases. One was the Heart of the Atlanta Motel case, and the other one was Katzenbach v. McClure, which is the Ollie's barbecue case. The argument was that these were local businesses and they were not connected to the national, the national government had no power over them. So under the Civil Rights Act of 1964, it was passed under the authority of the Commerce Clause. The Commerce Clause is one of the powers that Congress has to, the national government has to regulate interstate commerce, commerce between the states. These two businesses said, we have no commerce between the states, we are local businesses. The court said no. The court said that the hotel advertises around the country, people travel to it from other states, it's right near the highway, and therefore it's part of interstate commerce. And there's a Commerce Clause to regulate commerce among the states. And the court said the power of Congress to promote interstate commerce also includes a power to regulate local incidents thereof, including local activities in both states of origin and destination, which might have substantial and harmful effect upon the commerce. So again, Congress said, okay, we can't go under the Due Process Clause, but this affects commerce. And the court said, yes, it does, because with the hotel, people are traveling to Atlanta and staying at the hotel, so it's money coming from out of state to into the state. And in the barbecue case, Ollie's Barbecue, it said that even though there's no evidence of anyone from out of state eating there, it does, they do purchase meat from out of the state, they purchase supplies from out of state, and therefore they are participating in out of state commerce. So both of those businesses, the motel and the restaurant, had to integrate. They both had previously been segregated in that Black people could not stay at the hotel and they could not eat at the restaurant. So the court held that the Civil Rights Act of 1964 was constitutional, was a constitutional exercise of the national government's power under the Commerce Clause. Also, the Voting Rights Act of 1965 said that voting qualifications or prerequisites to voting or standard practices or procedures could not be abridged or denied on account of race, color, or language minority status. 2013, so the Voting Rights Act actually was quite successful in giving Blacks the opportunity to participate in their government and other minorities. As we noted in the 1880s, after Reconstruction, there were many barriers put up to Blacks from voting, including poll taxes, property ownership requirements, literacy tests, requirements of that people had their voter registration in hand, also threats of violence and arrest. And so the Voting Rights Act required that none of those can be put in place to prohibit Blacks from voting. And it was very successful, as I said. From 1875 to 1976, there were no Black senators. After the Voting Rights Act passed, we started seeing some Black senators, including Barack Obama, who only became the third Black senator after Reconstruction in the 1990s. But it's more apparent in the House of Representatives. So from 1929 to 1970, there were 12 Black members of the House of Representatives. From 1971 to 2020 to today, there were 115 Black members. So it really gave African Americans, Blacks, a bigger say in their national government. Unfortunately, recently, the US Supreme Court found that the enforcement mechanism of the Voting Rights Act is unconstitutional. The court said that nearly 50 years later, things have changed dramatically. Shelby County contends that the pre-clearance requirement, even without regard to its disparate coverage, is now unconstitutional. its arguments have a good deal of force. In the covered jurisdictions, voter turnout and registration rates now approach parity. Blatant discriminatory evasions of federal decrees are rare, and minority candidates hold office at unprecedented rates. The tests and devices that blocked access to their ballots have been forbidden nationwide for over 40 years. And this is seen as a really problematic decision for voting rights. And we're already seeing since then a lot of barriers being put up. For example, fewer voting sites in minority neighborhoods to make it harder for minorities to vote in the elections. Some commentators said this is like if you're standing out in the rain with an umbrella, you throw away the umbrella because you say you're not getting wet. So the reason why we've had such success in voting rights is because the Voting Rights Act, and now the court said the Voting Rights Act is unnecessary. We're now in a period of what has been called white backlash. So there's been a movement of government and courts have grown more conservative, and those courts that initially supported ending racial discrimination, or the people who initially supported ending racial discrimination now realize that it costs them power. Again, race is a social construct and it's all about power. And also for many whites, it's difficult to see Black people get power because for many, it's so ingrained in them that whites are superior and Blacks are inferior that it's hard for them to allow to see the equality as it plays out. And remember the 13th Amendment that said there's slavery is abolished except as punishment for crime. And what we've seen, especially in the past 30 years, is a steep increase in Black imprisonment rates, which is essentially like re-enslaving Blacks. So Black imprisonment rate at the end of 2018 was nearly twice the rate of Hispanics and more than 5 times the rate among whites. And there's been studies that show it's not because Blacks commit more crimes, just that the way they're being targeted by the police and prosecuted, and the sentences that they're getting are much longer. Blacks also represent 33% of the prison population, nearly triple their 12% share of the adult population. And nationwide, African-American children represent 32% of children who are arrested, and 42% of children who are detained, and 52% of children whose cases are judicially waived to criminal court. So if you're a child in the US over, say, the age of 12, you can be tried as an adult if certain requirements are met. And it's much more common for Black children to be waived to adult court and tried as adults. And once you're convicted as an adult, you have that adult conviction on your record, which forever reduces the opportunities you can get in education and work. And also in several states, convicted felons lose their right to vote. So again, taking away rights that they have gained because they have a felony conviction. So the use of the ability to re-enslave people for crimes has been used by the white power structure to keep Blacks enslaved or re-enslave them in many cases. Here's just some numbers. You could see the steep climb. The orange line is Blacks in prison. You could see the steep climb of that from the early 1990s. And crime has dropped off and imprisonment has dropped off in the past bunch of years. There's a picture that's always disturbing. This is the Louisiana State Penitentiary. And it's disturbing because the Angola prison, as it's known, is located on the site of a former plantation. And this picture in itself, you have all the prisoners are Black and the overseer is white. I think if you had a picture of the slave times on this plantation and this next to each other, it wouldn't look that much different. So a way to re-enslave Blacks and others. In the Louisiana State Penitentiary, 76% of the inmates are Black, and 71% of the inmates are serving life sentences. So essentially, lifetime slavery. They will never be released from their involuntary servitude. And this brings us to really contemporary day and the white backlash. And as you can see, as we know, Barack Obama was the first Black president of the United States. And for many, that was very difficult to fathom. And the white power structure did not like to see that. And as a result, I think as a backlash to that, we saw Donald Trump win the 2016 election, in which he really did evoke many of these white power structure issues that we've been talking about. And this brings us to Black Lives Matter. And it's not a new movement, it's carried through from the civil rights movement of the 60s, 50s and 60s through the 80s and to today. It's just a different name for the same issue, really fighting for equality in society. And we began several years ago to protest violence against Blacks, police violence specifically, really came to fruition when Eric Gardner was arrested for selling cigarettes, and police put him in a chokehold and ended up choking him to death. And it was filmed, but the violence isn't new. It's just that I think now we're all walking around with video cameras on ourselves, and so a lot of it's being filmed. And the name is to emphasize that the acts of law enforcement show that to them and other government officials that Black Lives Matter don't matter. And so the name came up to remind the police and law enforcement that Black Lives Matter to everyone. And here's a list of a non-exclusive list of all of the individuals who've recently been, over the past 5 or 6 years, have been killed by police, African Americans who've been killed by police. And you can see George Floyd at the bottom. So to wind up, and I'll talk about George Floyd in a moment because someone had a question about that. So I put this little timeline together to show the problems that we have right now, because we've had 350 years of racial discrimination from basically 1619 to 1964. And we've had 56 years of legal protections against racial discrimination. And in those 56 years, we have not undone the previous 350 years. And so people say, well, we have all these laws now, so we've done that. But the reality is that we have many years to make up for, and many years of having racial discrimination just really baked into our government structures, and they still do exist. And that's why we're seeing, even to this day, with all these protections, we're still seeing racial discrimination throughout our government and our country, and our government structures, including our court systems, our police systems, our law enforcement, our educational systems, all still have these baked in discriminatory structures that I think Black Lives Matter is starting to start that dialogue as to how do we look at the structure. So in the past, we've looked at individuals, that individuals are the problem. So we have bad police officers, but I think what Black Lives Matter is bringing to society's attention is that we have structural problems. Yes, we have bad individuals, but we also have structures that need to be reformed. And I think that is hopefully what we'll see coming out of Black Lives Matter, which brings members decide who belongs and who does not belong. And I think that is important to remember as we think about Black Lives Matter and how we move forward from this, that race is a social construct designed specifically to keep one group superior and one group inferior. And here's some readings that I recommend. I also recommend a couple of the articles that I included on the written materials that were distributed. And I will leave this slide up, and that brings me to a close. Thank you for staying with me on this short but long journey through our the history of racial discrimination in the United States.
Thank you, Professor Mark Brown, sir. Can we quickly
Thank
have
you, sir.
some of the questions? Some of the questions participants are
Thank you,
interested
sir.
to ask you directly. Yeah. So I request participants to ask some questions quickly
And
because it is getting too late now.
yep, I did go a little longer. And someone did ask specifically, oh, can you hear me okay? Yep. Someone did ask,
Yes, yes.
someone did ask specifically about my views on George Floyd. And I will
Yes, sir.
talk about that briefly. You know, I think the George Floyd issue and Eric Gardner and all the others that we saw the names really is nothing new. This has been going on for, you know, for the history of our country and even before when it was a British colony. I think what's changed now is people, it's getting spread around, you know, with the internet, with people having phones that can videotape. And so I think that's why it's starting the dialogue that, you know, we have these structures that discriminate, these structures that were specifically designed to discriminate. For example, our police, as we have police now, were originally created to bring back escaped slaves. So we have a system that was designed to target a specific race, and that's what it essentially does. And as we're seeing race, people stand up for their rights, those who feel that they are, believe that they are superior based on the color of their skin are pushing back. So when a police officer is confronted with someone who that police officer believes is inferior, the police officer reacts in a way that, you know, goes back in the history of the United States because of the structure and culture that that police officer was trained in. The police are trained by other police officers who are trained by other police officers. So it goes back through many generations. And so I think what we need to do, the answer is to really look at the structure of our law enforcement. And that's what I think, that's what I hope comes out of the George Floyd incident and all these other incidents, is that we really do look at how we can change our structures.
One more question. The racism against Black people, whether it is connected with crime rate.
Racism against Black people as is connected with crime rates. So there is like we saw, there's more Blacks who are incarcerated, who are convicted of crimes. And, you know, that's very complicated. And it goes specifically to how our system is structured. So the police historically have targeted African Americans, Blacks. So they're pulled over at a much higher rate when they're driving. So if I'm driving as a white person, I'm not targeted by the police. So I may have drugs on me or a gun on me, but I won't be stopped. Whereas if you're African American, you're more likely to get stopped, which means you're more likely to get searched, and they find the gun, they find the drugs, which leads to prosecution. The laws were written in a way, consciously or unconsciously, the criminal laws, to target certain minorities. So for example, for many years, if you had crack cocaine, which is cocaine in a rock form, it was a very serious penalty of, you know, many, many years in prison. Whereas if you had it in the powdered form, it was a very small penalty. Now, whites generally used cocaine in its powdered form. Blacks generally used it in its rock form, in the crystal form. And so it was a law that targeted and gave greater punishment to Blacks for essentially doing the same offense. So we have Black people are targeted by police more, also because historically Black people are given fewer opportunities. You know, as we said, education is key, as many of you probably know because you're educators. Education is key to providing opportunities. So if you provide inferior education to Black individuals, they're going to have fewer opportunities. So they're going to be more likely to turn to criminal pursuits to get resources, to get money, to support themselves. They also grow up in areas because of our racial restrictions, historic redlining. They grow up in areas that have higher crime rates because there's been more poverty in those areas because they've been ignored by the governments to provide resources. So I think the higher crime rate among Blacks has to do with a lot of our structural history of discriminating against Blacks in our country. And I think resolving it is going to take not just reforming police, but reforming education, really looking hard at how we educate, really looking hard at how we integrate our cities and how we provide resources to everyone, and redistributing some of those resources to benefit those who have been historically denied those benefits. So I think it's going to take more than just reforming the criminal laws and the police. I think it's going to be a much broader societal change that we need to look at.
We have a question from Sabine Michael Joseph. He says, are people of color more prone to have evidence planted on them?
Are people of color more prone to have evidence used
Planted on them.
evidence
Planted on them.
planted on them? I've never seen studies about that. I would suspect so just from my experience as a criminal defense attorney, but I've not seen any studies that would indicate one way or the other.
From Sri Harsha, does the superiority complex of whites responsible for the problem? If so, does the law can prevent these social evils?
Can you repeat that?
Yeah. Does the superiority complex of whites responsible for the problem? If so, does the law can prevent these social evils?
So yes, I think the fact that many whites still feel like they are superior based on this socially constructed concept of race does lead to a lot of the issues we see today and the discrimination we see today. And I think we've seen that come back in full force in the current election, presidential election in our country. And I think it's hard to legislate morality. You know, I think you see that in India, you see that here, that you can pass all the laws you want, but you know, you can't make someone into a moral person based on the law. I think in many ways, really more integration is the key. You know, places where individuals are well integrated, there's less racism, because when you meet someone as an individual, they no longer become a race, they become an individual. And those stereotypes that you're told go away because you meet someone and you understand this person isn't how I'm told they are. And so I think having historically separated the races has led to this feeling of superiority. And so I don't think you can create morality or change morality through the law, but I think you can do so by providing more opportunities for integration.
Yeah, there's one more question. Is it from Sabine Man again? Is it practicable to purge an entire police department and replace them with a highly and properly trained new batch of officers who would probably not target people of color?
Is it possible to purge a whole police department and replace it? I think that would be very difficult. I mean, it depends on the size of the police department. If it's a small town with 3 or 4 members of the police department, probably easier than a city like Portland with hundreds and hundreds of police officers. I mean, I think in part we have to look at what we want our police to do, because in the United States, the police are not only law enforcement, but they're also in many ways social workers, in that they are told they have to deal with people with mental health issues and the such. And I think we expect too much of many of our police. And so I think part of what's being talked about is, you've probably heard about it, defunding police. And I think many people are talking about not abolishing the police departments, but really limiting what they do and creating other agencies to do other parts. For example, to deal with people with mental health issues who might be having a mental health crisis, that police shouldn't be doing that. So take money from the police, move it to a new entity, a new agency that deals specifically with, say, mental health issues. In fact, so I was talking to two of my clients the other day, 2 different times, both of whom are in prison for many, many years, both actually committed murders. And both of them said, we would think it's crazy to get rid of the police because you need police because there's crime. And so it was ironic that my clients who have been convicted of crimes and are in prison are saying you need police officers. And so I think it's the question isn't getting rid of police. I think you're right. It's restructuring police and reforming police. You're muted. You're muted. You're muted.
Sorry. Yeah. There's one question from my wife, Smita. Am I audible? Can you listen to me?
Yes.
Yeah. Yeah. She says President Trump has frequently said that no president has done more for Black people than him. Do you agree with this statement?
Surprisingly, no, I don't. Or not surprisingly, no, I don't. I don't agree with that statement. There's and I think in his world he has. I think he believes he has. And there's also a line. He also says a lot. I'm the least racist person you'll ever meet, and I don't have a racist bone in my body. Most people say if you have to say that over and over again, it means you probably are racist. So I'll leave it at that.
Okay. I have a question.
And I do see I do see that my parents are here, so I'll say hello to my parents who are in Florida.
They are welcome. Welcome, Professor Mark's parents. It's really nice to have you, and it's our honor to be part of this program. Thank you so much for being on this particular program. Can you put on your video so that we can see you?
They may or may not be able to.
Okay. Thank you so much. Thank you, Professor Mark, for requesting them to be part of this particular program. I have one question.
Yes.
Instead of, as Sabina Mann has said, is it possible to change the whole lot of the batch of notorious police and replace them with another batch of good police as we expect them to be? If it is not practically possible, is it possible, or has it been going on, that they have a training to sensitize as far as the Blacks are concerned, how to treat these people? Do they undergo any kind of training so that they can treat them equally?
They do have training. Most police officers do, kind of racial sensitivity training or whatever they call it. Unfortunately, it's always been something in the training that, okay, now we have to sit through this training session and people will have their phones out. And, I've actually sat in some of them and they're not at all paying attention. It's just a requirement that they have to meet. So it's like, okay, we checked off that box and now we can move on. So I think it is given, but I don't think it's given effectively. And I should kind of note that there are good police officers. There are police officers who really do care and are really sensitive to these issues. And so it's not, it's like with any kind of talking about a group, when you talk about a race as a group and you say this group does this, every individual is different. And I think it's the same with police. Every individual police officer views policing different, views race differently. And so I think that has to be accounted for as well.
Who is more responsible, do you think? Who is more responsible? During elections, you need their votes. And as far as this kind of illegal activities are concerned, nobody seems to be supporting them. Yeah, we have seen some white people also coming on the streets against this kind of activities, and we call it as Black Lives Matter. But things go on repeating itself. Where is going? What is going wrong, and where?
Mhm.
Do you think?
What's going wrong with
And where? Which needs to be repaired.
what needs to be repaired? Oh, that's a big question. I think
Because law doesn't
think we
seem
need-
to be working. Law doesn't seem
Right.
to be working.
Well, I mean, it has to a degree. I mean, we've made great strides since the 1800s and 1900s. We no longer discriminate based on race in hotels and in trains. So there has been progression made. There is better education. I think, really, to me, and this may be my background in education, I think to me, the focus needs to be on education. You need to educate, you need to provide excellent education for everyone. Black students are far more likely to drop out of school. They're far more likely to be punished, to be suspended from school than whites. And that leads to them dropping out. So I think that, to me, is the key. If you educate anyone, you're going to provide more opportunities for them, and you're going to invest in their future. And it goes down through generations. So once you have one generation that gets a quality, good education, the following generation, that family will also have that opportunity. So to me, if there was one thing that really needs to be focused on to eradicate racism, it's education in our country. And like I said, I think there's always going to be people who want to feel superior to others based on the socially constructed concept of race. I don't think we'll ever get to a society where no one is racist. I think we just have to get to a society where our government structures are not racially biased, and that the majority of the people, the vast majority of the people, believe in equality for everyone.
My suggestion,
and I think education, and I think education is the key.
yeah, my suggestion would be, if it is giving education, that will change the things around. But the education should be on an equal footing, right? As we have discussed, that there are compartments, different kinds of divisions of even the educational institutions. Even in trains, we have seen that there are different compartments for the blacks and whites. So instead of having different classification of educational institutes with minimum number of facilities, why don't we have a mixed educational system where all blacks and whites can sit together with all the facilities? As we see in movies, blacks and whites, they are equally using all the facilities of the education institution wherever they go. Whether it only happens only in movies, or really can it be one of the solutions?
No, and I do think, in most schools there is integration. There are very few all white schools and all black schools. It's just that, for example, like in Portland, where I live, there are historic settlement patterns. And so in areas where, and the schools are based on geography. So a school may have pull from students from a certain area. And so if that area is historically a white area, it's going to have a majority white population, and schools in black areas have a majority black, but they're I mean, there is some integration. I think it's just that it needs to, there's still discrimination in the school system.
Thank you so much,
E- e-
sir. Yeah. Thank you so much.
And
Yeah.
it's, I mean, some of it's implicit biases. It's not explicit bias. It's not that a person is expressly discriminating. It's that it's just, they don't even realize they're doing it.
What I see is these things are happening as per the incident, based on the incident. If a black man is caught violating the law, he will be treated differently than the white, as you already said. If I'm driving with a car with all loads of some illegal things I may be carrying, I won't be stopped. But if a black is stopped, all those things on him, he will be legally tried. Isolated incidents, I think. And in our country, we have abolished untouchability, and we have converted that untouchability into a crime now. There cannot be any kind of ill treatment to the lowest caste of caste people. So we have converted that activity into a criminal activity. So my suggestion would be, whoever violates the law, collect the fine from them and invest that money for the betterment of those who are victims. So that would be the punishment, so that nobody would go for violating such kind of laws. That may be one of the solutions that I see.
Yes.
Punishing them severely by collecting fines. Okay, thank you so much for your time. I will hand over to Dr. Chandrani Bagdi Madam.
Thank you.
For the further process of the program. Thank you so much, sir.
Thank you. Thank you, sir, for highlighting the historical background also so nicely, and also the Bhagat Singh's case, which we did not
Wonderful,
have an
sir.
idea about this, and also the comparison between the Constitution of the Indian Constitution and the US Constitution. It was so nice to hear you. Next, now I request today's chairperson, Advocate Malushte sir, to express his few words.
Good evening,
Hello,
everybody.
Malushte
And
sir.
yes, good evening, everybody.
Good evening,
Yeah.
sir.
I think I am audible.
Yes.
Yeah.
And I
Good
Yeah,
evening,
you're audible.
everybody at
Yeah.
India, and good morning at America.
Yes.
Today is Dasra. We are celebrating Dasra in India. And I appreciate that Professor Dr. Mark Brown started his speech with Marathi, and he has wished us good luck for Dasra and Diwali. I appreciate his tutor, Dubdale sir, who might have taught him Marathi in less time. Dasra is known to be a festival of beginning good things. And I appreciate Dubdale sir and entire team of Shivaji University, as well as the authorities of Shivaji University, for giving such a nice opportunity to hold this international webinar today. At the outset, let me thank and appreciate what was being told by Professor Dr. Pinario sir. Dr. Pinario sir has been very kind to Shivaji University since many years back. I appreciate his telling us the topic of today in the historical perspective, and it became a sort of warm-up for the webinar today. I would appreciate Pinario sir as well as Dubdale sir to continue interaction at Shivaji University by Pinario sir with all our students. Thank you very much, Pinario sir.
Thank you.
The session begun by Dr. Mark sir was not only interesting, but it was a challenge in itself. He has so well shown us the entire theme covering 400 years and within a span of 1.5 hours. With his effective PPT, he has done it in a so lucid manner and a lucid language that we came to know many things which we earlier did not know, although we had read about it, but we got an in-depth knowledge of the topic. I appreciate you, sir, and I request Dubdale sir that this will be just a beginning, because today is Dasra and we begin good things. So international webinars and interaction with Mark Brown sir is just a beginning today. And I request Dr. Dubdale sir, with all his active participation as he always does, and with numbers that we have. And thank you very much, sir, for giving the opportunity to chair the session. And I wish all the best to Shivaji University, all the students, all the participants. And I look forward to meet you all in such programs to be conducted. I wish all the best to Dubdale sir and the entire Shivaji University LLB and LLM department. And with these few remarks, I conclude my chairperson's view. And I wish you all the best. And I put in my all gratitude to Dr. Mark Brown sir and to Pinario sir. Thank you, Dubdale sir. Thank you, Chandra madam, and thank you all. Have a nice time.
You're most welcome, sir.
Thank you, sir. Now I request Dr. Dubdai, sir, Head of Department, to express his vote of thanks.
Okay. First of all, I appreciate we have almost 72 participants. So thanks to all the participants for being with us for more than, I think, 3 hours. And I appreciate Professor Mark Brown for having so much, covering the entire historical aspect and even the latest position of racial discrimination that is been going on in US and the possible solutions that can help Black people to survive with equality in US. And we have already seen all the practical examples that he has discussed. So thank you so much, Professor Dr. Mark Brown, sir, for your exclusive and, as you said, short but long session. And I appreciate all the participants for being with us for so long and listening to you and watching your PPT so patiently and asking some interesting questions. And they were already answered by the resource persons so nicely. So thank you, Professor Mark Brown, sir, for being with us and for sparing your valuable time with us in spite of being busy in your practical work. We also had Professor Dr. Marian Pinero, sir, who was my principal at Law College, and for guiding us and for being a chief guest of this today's function. Thank you so much for being with us, sir. We also have Advocate Rajshekar Malusti, sir, who conducted a chairmanship of Professor Mark Brown's session, and he has also concluded and also explained briefly about untouchability and slavery, and he has differentiated in between and then explained what do you exactly mean by untouchability and how it is treated in India as far as the law is concerned. It's a criminal activity. Whoever does it will be arrested and there is no bail for it. So it is so dangerous crime, right? So we thank from Shivaji University Kolhapur and Department of Law on behalf of both the institutions. I express my sincere thanks to all of you, especially Professor Mark Brown for his wonderful session, and for all the participants who, in spite of being busy with the festival, they took time and joined this session on my request. So thank you so much. So thank you all. Over to Dr. Chandrani Bagri, madam.
Thank you, sir. And thank you all the participants, speakers, chief guest, and Malushya sir also. So thank you all again. So like everybody is asking in the comments, share the feedback form. So feedback form link will be shared in a group on the WhatsApp group. One thing I would like to tell that please give your correct email ID, because if you don't give your correct email ID, the certificate will not be sent to your email. So the link which will be sent to your group, you should submit, you should click on that link and submit all the information correctly, and after submitting within 5 to 10 minutes you will receive your certificate.
Hey,
चंद्रनी बागड़ी मॅडम म्यूट झाले. Unmute. Dr. Chandrani Bagri madam, please unmute your audio. We can't hear you. Please unmute.
Yes. Okay. Sorry. Okay. Sorry, sir. So, feedback link will be shared on the WhatsApp group, and all of you should fill the correct information once the link has been shared. One request to all of you that please give your correct email ID. If your email ID is wrong, you will not receive a certificate. So while filling the information, be very alert and fill the all information very correctly. After submitting, your certificate will be received on your email within 5 to 10 minutes. And one thing I would like to tell that the capacity of this particular Google Form certificate is only 100. So if it is like, if it
100
goes
per-
beyond 100, you will 100 per day. Okay. So if you not receive today, you will receive tomorrow or day after tomorrow. So don't worry, everyone will receive a certificates. So just be alert and fill proper information, because once you submit, we can't do anything and we can't again send you the certificate, because it is like the link will be opened only for the once. So everyone again, thank you. So can we end the session, sir?
Yes.
Any doubts?
Okay. Now we already had a long discussion with the questions also, and we had an opportunity given to the participants. I don't think anybody is interested more in asking questions. Professor Mark Brown has covered everything in detail, and literally he took us into the past in 1619, and then he brought us to the latest situation also. So I think everything has been covered and everything was clear. I could read the comments from the participants that they have learned a lot from Professor Marx, sir. So thank you so much for being with us, and thanks to your parents exclusively for being on this particular program. I give my regards to them, sir, and my regards to Patricia ma'am also, who might have helped you arrange this particular session of yours. I'm sure she has a little bit contribution also, though we could not see her on the video, but please give my regards to her. And then all other participants who might have joined because of your reference, sir. So thanks to them also for being with us. So thanks to all. And
Thank you.
I would like to end the meeting now. Before that, I would like to inform all the participants that I'm going to share the video. It's been recorded, and I will share it first, upload it on my YouTube channel, and the link will be shared on the group. And I will share the video with Professor Mark Brown and all the other resource persons, Dr. Marian Pinero also, and Advocate Malush Desai. So you will have all the entire PPTs with you in the form of a video. So thank you so much, Professor Mark Brown. See you. Have a nice day, sir. Take care.
Thank you all.